as a site visit,
Yeah.
but also.
Yeah.
Recording in progress.
Good evening. I'd like to welcome Attorney Jim Wilson, and I'm sorry,
Jess,
Becky.
Jess Vecchi, our litigation counsel.
Jim is the counselor for the Old Kings Highway Commission, and he has volunteered his services. They both have for our benefit tonight. So, Jim, would you like to set the table for us or get right into our questions? Your choice.
Well, I think what I would do is hand out the usual, if anybody has not got this, I did briefly put a little addition into it concerning the climate bill notation, but
Thank
I sent
you.
a letter on that to everyone anyway, so they should have the basic change that was made.
Thank you.
Or addition that was made.
Thank you.
And,
Thank you.
But anyway, what I'd like to do is follow this basic outline that we've been using for a number of years in these workshops, because it tries to cover in a simplified manner the basic points that you need to keep in mind as you carry out your duties as a member of one of our local town committees. And as I have experienced over the years, you folks are the ones that make the act work, or however it's to be implemented within your town. The success is oftentimes how you handle your approach and trying to stay within the structure of the law, the rules, the regulations, and the many variations that have evolved on the act. Now, a year or so ago, I was in here, and you have a video recording of that session, which was an hour, similar to this one, planned. But in looking at it, going back over, it appeared I spent the first half hour just talking about open meeting law and talking about public records and conflict of interest, which are the state statutes that are universally applied to all committees and all boards of a town or of the county. And so I'm not intending to dwell on those, even though you need to keep it in mind that in the legal structure here, and there's, I believe, a question raised on that issue of the pyramiding of authority, of what comes first by way of law, what comes second, what comes third, what comes fourth. And if you look at the pyramid idea of the regulations, you have what we call we have the federal law, which is the federal constitution, which occasionally will come into play whether you have a religious issue, which is all federally protected, or if you have things that we all recognize on a federal level as constitutional rights, and those are a superior authority, as I think we're watching today in the national picture of the rules and how they're interpreted, and most importantly, how they're applied to, as you come down the pyramid. With us, we're a creature of the state legislature. That is a special act of the state legislature 52 years ago, created our district law, our regional district, and it also was endorsed by a referendum to the towns that adopted it. And basically, that state law being what we call a special act of the state legislature takes precedence over the next level down, which is your town bylaws and your town local rules, so to speak. And that comes into play when you get into what we call demolition, removal, demolition by neglect, demolition period, and the effort by towns to create a bylaw in their town to regulate the removal or demolition of historic buildings. Now, one of the unique features that we have and we enjoy because we are a direct creature of the state legislature, our act does not have a time limit on trying to protect or save the building. That is, that the town bylaws that have been considered and have been adopted have been very wary of violating reasonableness in saying, okay, we're going to suspend the right to demolish for 6 months, or we're going to suspend for a year. But the farther out you go, the more they fear a constitutional challenge that you're taking somebody's property without just compensation when you say they can't remove their structure or dwelling in order to use the land as they would wish to do it. So our act, which is a direct creation by the state legislature, takes precedence over a town bylaw. And it is for that reason that you will see in the towns that towns create a town bylaw for their whole town-wide geographical area, but you'll hear that Old Kings Highway is not governed by that time limit, is not subject to that limitation on the ability to deny a certificate for demolition or removal. Now, when you have a town bylaw, and occasionally you'll see a town bylaw that just goes town-wide and doesn't mention the OKH, the way that would properly be interpreted is that you have two regulatory authorities governing the demolition or removal of the structure. Oftentimes with the town bylaw version, they give it to the Historic Commission for the town, which is a different entity than us as a historic commission. It has a different role in the general laws. And what a historic commission's responsibility is to inventory the assets and to identify the historic assets within a community. The historic district committees, which you are, is a regulatory authority that gets to decide whether or not a building could be removed or demolished. And you would use the Historic Commission, if you have an application or you're involved in an issue, to provide the history or the information or the value of the particular structure and to feed that information to you through their inventory and through their efforts to document the historic sites and buildings within the OKH. And that provides factual basis for your determination if you were to deny a certificate for demolition or removal. But it's important to keep these little entities in mind as you administer situations with demolition and removal, which the state legislature has given you authority over. Now, as you probably all have had experience with the problems of demolition and removal, is that you have a law from the state legislature that is subject to the authority of the building commissioner for public safety reasons to order the demolition of a structure, a historic structure, for the interest of protecting the community's safety. And that conflicts sometimes between your role and the role of the building inspector or building commissioner in trying to protect the buildings or structures along with paying deference to public safety. And we've had a number of situations in other towns as well as here where a person will allow their property to deteriorate and create a public safety problem and go and seek a demolition permit from the building commissioner who has that authority. A interpretation that I would encourage is that you have a good working relationship with your building commissioner or inspector so that he uses other avenues to compel the owner to prevent a hazard to the public by fencing the property or taking other steps, alternatives to just permitting total demolition. That's something that unfortunately does rear its head from time to time, and we do lose historic features or buildings. But being vigilant, having that good relationship with the building inspector and being told when something is coming up, and being able to react to that. And most building commissioners are very good about communicating with the Historic District Committee, but occasionally there'll be something where we lose a building or a structure, and obviously once it's gone forever. But anyway, back to where I started with this thing. So we, as a creature of the state legislature, have a leg up on a town bylaw. And also, as I say, the duality theory that if you have multiple regulations affecting a project, the applicant has to comply with both. That is, that fact that you have a bylaw in the town, created by the town, and you have the Old Kings Highway Act, gives you two places that must be complied with, in the same sense that zoning or conservation or other authorities may have dual jurisdiction over a project or whether it is to be allowed or not allowed. You could go through the process of trying to get a permit from this agency, the Historic District, and the person still has to go to conservation, still has to go to the zoning, etc. And that duality is something that is respected by the law. So that wandering off into the issues of exemption, etc. I noted that in the questions or in the topics of interest that were previously given to me, there was a question about the open meeting law, which is covered in the first section there, and a question specific to what we would call potential site visits and going out and viewing a property. And as I think Bob indicated, I watched the video of your questions and the discussion there, and Bob pretty much hit the nail on the head with what my opinion is. That is, site visits are hazardous to the open meeting law, even though they are specifically permitted under the open meeting law. The problem, they've been construed and interpreted, that is the open meeting law regulations, to prevent you from deliberating in any situation where you have a quorum of your committee. So if you go out to a site visit and you have 3 or more of your membership there, and somebody starts talking or communicating with another member or with the applicant, and all within earshot, you suddenly create a potential violation of the open meeting law because you are, as you speak, talking about how you feel about the project or how you would judge the project or whatever. And it's very easy to go off that slippery slope. And then you have a violation of the open meeting law, despite the fact that the open meeting law says you can go take a site visit. What the open meeting law has been interpreted to mean is that you can't, when you go on that site visit, deliberate, which means communicate amongst yourselves or with the applicant. And it's viewed from the thing of transparency. That is, when public boards, as you are going to be making a decision, the public has a right to have notice and to be there to hear what is said and what is done, and to be able to know exactly what the committee is thinking and doing. And you can't mask that communication in a site visit or some other way, or even in a workshop like we're having today. That is, this workshop is specifically permitted in the open meeting law. However, if we start deliberating about policies and rules of how you're going to administer the act here in Yarmouth, you get yourself once again into a deliberation process, and then the open meeting law kicks in and governs what transpires or what we do. That's why we need to be very careful that this is a training session, a teaching process, and not a sitting and making policy for how you're going to judge applications or what you're going to do. And that's just, unfortunately, the rules by which the state legislature is deemed you will conduct business, and that takes precedence as with our act takes precedence. That's just the way it is, in my opinion.
So a question on that. This was announced to the community that this workshop was taking place, and they were invited to listen in.
Mm-hmm.
So haven't we given them due notice?
We do. This is the way we handle these. We do the advertising, 48 hours notice, post the meeting, let it, and generally my policy in conducting these is if somebody shows up, wants to come in, fine, we've got nothing to hide. We're not trying to deliberate. We're not trying to change things. We simply are going through a training exercise. And that's my attitude towards it. And when I do this, if somebody knocks on the door and says, I want to sit in, or a reporter comes and says, I want to sit in this, absolutely, you're welcome. You get into very thin lines here with the open meeting law or with your meetings. You are supposed to keep the doors open so that people can come and go during your hearings and your meeting of your committee in compliance with it not being a closed session. When you close the doors, it's viewed as a closed meeting and depriving the public of being able to come in. In this case, I think we're probably being recorded, we could be being broadcast, and just to better be able to communicate, the door is closed, but that's not barring the public who want to tune in or know that this meeting is taking place.
So, Jim, following up on Cindy's question, so the chief distinction, as I see it, between this training session and our published hearings is that the public is welcome to witness but not welcome to engage.
And you're not welcome to deliberate in this process. In other words, to deliberate about something that is pending or will be pending involved a particular case. You start to get into the nuances and the details of it, but generally, my philosophy has always been to respect transparency. The public has a right to know whatever, and we have nothing to hide, and that's been my philosophy. And that's why I try to encourage the town committees not to do site visits as a group. I do encourage, and with our regional commission, the commissioners each go to the site by themselves, not in the company of anybody, there's not a quorum, there's not anything else, to familiarize themselves with the setting, to do the 360-degree look around to see what's in the neighborhood, to see the property in question, and to do it on their own instead of doing it as a group. Now, I realize that some boards and commissions will do a site visit as a group, and they will be hopefully very careful that they are going to look with their eyes and not talk about the project, because it's that slippery slope where you very quickly get yourself into trouble. Plus, when you step back and you think about this, the process by which you make your judgments is like a judicial process. That is, you hear from the applicant, you hear from the public, you see the plans, you see everything in a very public, open manner. And based on that, you deliberate and make a judgment to grant, not grant, whatever you're going to do. That process gets breached to a certain extent when you, as a group, go out and do a site visit, because you're having contact and you're putting yourself into a position of somebody saying, well, gee, you know, I heard Bob and John talking about the roof and talking about this or talking about that feature at that site visit, and that was a violation because they were making up their minds by that discussion as to how they were going to vote when they went to the public session, and that was prejudicial and improper. So that kind of concern about how you conduct your procedures is part of why we have these workshops and part of why we try very carefully to cross T's, dot I's on our practice and procedures so that Jen doesn't get an appeal to deal with.
So, I'm sorry, to clarify, just for tonight, for this workshop now, it's been announced to the public, it's been posted in the newspaper, but you said we're not meeting open meeting law, so we can't deliberate. What additional steps would need to be taken so that we could deliberate on something during this workshop? What are we
It
missing?
would be next to impossible, really, because you get into so many subject matters when you're in one of these training sessions that it's very easy for the discussion to wander onto, well, tonight we've got this case coming, and gee, you know, I'm not quite sure on solar panels if the way they lay them out is the right way, et cetera. The next thing you know, you're making a decision here instead of in the public meeting. And so I would basically stop if we were going into.
About a specific application. I agree, about a specific application, but what about a generic?
If you're setting policy, if you're discussing, well, what's our policy going to be on, I guess, demolition or something, just take any topic that you deal with, and you start setting guidelines of how you're going to make your decision and getting a consensus that, okay, we're going to treat these this way or that way, you're into deliberating because it sets the table, so to speak, for how you're going to make your decision.
So when is
on
it okay to deliberate then? When can you deliberate? When is it okay for us to deliberate of a topic of generic interest?
The proper way to do it is you set up a public hearing on the topic, and you meet with a quorum, and you advertise, and you follow open meeting law, and you say, hey, we're going to consider whether we're going to exempt sandwich boards from street signage, or we're going to do this, or we're going to do that. then you really should comply with the open meeting law, because you are actually setting the rules by which you're going to determine whether to grant or not grant a certificate of appropriateness or whatever you're going to do.
Can it be done at the end, like of new business at the end of one of our typical meetings?
If it's on the agenda.
It's on the agenda,
sure.
okay.
But it's maintaining transparency. I mean, it's kind of, and there, I hate to go down this, but there's judgment calls that you make, that Lisa will make, that I make, about how far do you go, like talking with the doors, are they closed, are they open, all these practice and procedures. The more openness and transparency, the less trouble you will have from the state coming after you for violating the open meeting law or the public records law or any of these regulations. If you show good faith, as opposed to running the risk of somebody accusing you of, doing things improperly. Boy, I got going on that one.
Sorry.
Let me just say that I would like to get into the bulletin, and I mentioned this the last time. The bulletin is our effort to give you a guidebook for implementing and administering this law. And it's something that has evolved over 50 years of administration. And hopefully the layout of it is fairly clear in the fact that you start with the statute itself, that is the statute as amended. And that is the first section of that book. And because the book is a special act, not what we call a general act of the legislature, it is unique to us. And as I've said, and I'm sure you're aware of it, we are the only regional historic district in Massachusetts. And we're a creature of the legislature through a special act. And it's not in the general laws. Most of your general laws are codified and called the general laws of the Commonwealth of Massachusetts, and they apply universally throughout the state. And our act is what was enacted in 1973 and 12 amendments that have been made over the years by different legislatures, amending, such as when we amended the act to go from one alternate to two alternates, when we made changes in it over time that became necessary in trying to refine the administration of the act. Originally, when this law was crafted back in 73, 74, appeals would go to the Superior Court, just like appeals for zoning and other things go to Superior Court. We found that because the Superior Court is made up pretty much of a transient collection of judges and have a lot on their plate, that we turn to the district courts, which are totally, for the most part, local. That is, the judges live here on Cape Cod. They understand the district. They understand what we do. Oftentimes, as Jen would indicate, a part of the process of taking a case up on appeal is to educate the judge to the rules and what we are and how we work, so that they have the local flavor, so to speak, of this historic district. And it is something invaluable when you consider the type of regulatory authority that you exercise when you make these individual decisions on the applications. That is, the character of 6A, the character of Yarmouth, the character of Sandwich, Orleans. All these are a little unique in the sense that when you deal with 6 different committees, and you can see it visually if you drive down 6A, because you'll go from one town and you'll see signage that is overwhelming. You go to the next town, there's no signage, or at least limited signage. Similarly, you deal with solar panels, you deal with types of architecture, you deal with all kinds of aspects of regulating the appearance and the aesthetics of the designated historic district itself. And that is something that we changed the act to go to the local district court to get a speedier review, also to have courts that were more familiar with the local character of Cape Cod. And so that was one of our changes, I think 5 years into the act that we did that. But anyway, back to our outline and try to stay here. If you turn to page 2 on this, and I sort of didn't get totally through this with the prior hearing that is recorded, and as I understand it is available still for everyone to see. You go through the factors that a town committee should consider in acting on an application. And I broke that into 3 types of certificates that you deal with: the certificate of exemption, the certificate of appropriateness, and the certificate of demolition and removal. Yeah. That certificate of exemption, when you look at it, is defined what qualifies for a certificate of exemption. Occasionally there'll be some question or ambiguity about what would qualify to be exempted, and it's exempted from a public hearing and the structure, the procedural structure that certificates for demolition and appropriateness go for. That means usually it's something that has been found or determined to be less significant in its impact on the district, on the setting, and certain items for practicality, for procedural process, have been exempted. And the procedures that have evolved, we used to have to require the committee to vote on every one. Then we changed it, and this was one of the amendments we put through, allowed the designee of the committee to sign off on a certificate of exemption after reviewing it and saying, yes, this qualifies, or it doesn't qualify. But we still get into questions of, well, is it viewable from a public place or a way? And that's a judgment call, because you go there in the summertime and there are leaves and you can't see anything. Then you go in the wintertime and the leaves are off the trees, and lo and behold, it's big. Or some other types of factors that make the determination to be a judgment call by that designee. And the designee sometimes will say, look, I don't know if I'm going to issue, I don't want to sign this, I want it to go to the committee. And the committee will look at it and make a determination and a vote by the committee to approve the certificate of exemption or to deny it. And that's something that will come up from time to time, of interpreting the certificate of exemption quality. And also, as you think about this act and how detailed it is in regulating so many features, so many factors, it would become an administrative nightmare to try and put everything through the committee process and the public hearing process in order to make a judgment on whether it should be allowed or not allowed. I did notice that that issue did come up in your discussion or in the questions, and I guess the position I would take is that is a judgment call to be made. I encourage the use of the chairman or vice chair or a designated person who has the time to go and look at what is being requested and can regularly be available to process these so they don't get bogged down or backed up. We enacted the one for solar panels. Now it's getting on to 4 years ago that we put that in, and that's kind of very structured in qualification, but it was a way to relieve some of the stress caused by the demand for solar panels and to try and allow permitting of them by the community without over giving up the regulatory authority that you still have today. Which brings me to another one. Do you want to comment? There was a question in there about the climate bill, I think, that the
Jim,
change.
is it all right if one of our committee members or,
I think Mr. Grady's,
A quick question on the, if the designee feels that they don't want to, for whatever reason, make the decision on a certificate of exemption, want to refer it to the entire committee, does that have to go to a hearing then? Would that have to go to a hearing, or could it be done informally to the committee?
the committee, you would probably have it on the agenda.
That answers my question.
You know, that would be it, but you wouldn't have to send notice to everybody that's in a butter or, you know, all of that extra stuff that comes with an appropriateness or demolition.
I can answer how how I've been handling it since I'm the designee who does the exemptions.
Better you than me.
If it's not a slam dunk, I tend to require a COA, a certificate of appropriateness. If I'm convinced that it's A, not visible from a public way, B, not on a sensitive structure, which is to say an antique structure, in which case, even if it isn't visible from a public way, I would hand it over to the committee in the form of a COA. So my position, in short, is when in doubt, COA
It would have to go on an agenda.
would be going on an agenda.
It goes for a COA, then you gotta do the notice and the public hearing and get the public involvement, so to speak, in order to meet due process for the owner. That would be always error on the side of due process.
Most requests that come before us are pretty clear-cut. That it would be a waste of our time collectively to have to deal with them, and it doesn't impact the public interest in a negative way at all.
I was gonna ask Jen if she would help us with the meaning of the last legislation concerning the substantial weight.
So what we're talking about is on page 2, section C, certificate of appropriateness and the 6 factors that Jim has broken section 10 down into.
Yes.
And so section 6, item 6, the energy advantage of a proposed solar or wind device, the legislation basically says that you have to give substantial weight to the threat posed by climate change and the Commonwealth's obligation to meet greenhouse gas emissions limits. Pretty vague, but stay in your lane and just consider it, and make sure it's mentioned on the record. You know, that you go through the motions of exactly what it says, it's broad, but you have to address it.
Is it an absolute obligation of the Commonwealth, or is it just an aspiration?
Well, I think that there's definitive, I mean, it's up for interpretation, but
It's subject to interpretation, but you have to go through the act. See, you as a judge have been told by the legislature that you shall consider this factor and give it substantial weight, but you're still the judge. The legislature could have taken away all control and just said, these activities will be exempt, period. The legislature did not go there. They said, we're going to trust the committees to make the right decision and to give them the flexibility still to consider the factors of the historical value and significance of the structure of these other factors that are enumerated under Section 10 of the Act. So it is one of the factors, and then your decision or your judgment on the application should consider, and this is a directive that you shall consider the environmental aspect of it, which puts more of a burden on you as you go through the process, but it doesn't mean you have to approve everyone. That's, you know, it's a judgment call, and you serve like a jury, and that's why these decisions are made by a committee as opposed to one person. In other words, when you deal with building code, it's all spelled out in structure, so many feet this way, such this, all those different aspects. And the building commissioner can sit there, as you could sit there and say, okay, how far do we go? How many feet do we have to go? What do we have to do under the state building code? But when you come to OKH, it is a judgment call based upon the Section 10 factors in weighing those as a jury, and it's a judgment that will vary from property to property. And remember, all property is unique, even though you may think it's all the same. Every property is unique, and I guarantee you go up to anybody who owns a home or owns a house or owns property, and they would be outraged if you said, oh, you're just a cookie cutter, just like the house next door or whatever it is. And in fact, a question was raised in what Lisa sent over about exempting geographical areas, which has been around from the beginning of the district. And we did that in Brewster probably within 5 years, around 1980, after we had created the district. And we did it because we were going to lose Brewster as a town. That is, if you look at Brewster, it is almost 100% in the district, the whole town. And they had a lot of open space for development, and the town people felt, look, we want to develop all this land. We want to be able to put up whatever we want to put up. We don't want a committee saying that it's inappropriate to put this building or that building or whatever. So there was a strong movement in the town politically to take Brewster out of the district, literally, despite all the captain's houses, despite all of the historic features. And so we worked very hard with Brewster, with what was going on, and what we came up with is, okay, we'll keep we'll make a deal. We'll keep you in the district, but we're going to only put properties that are within 500 feet of 6A, of a couple of other scenic roads, will be regulated. The rest of them, we're going to issue a certificate of exemption and exempt them. Now, in order to do that, We had to draw up legislation, go to the state, put it through a state process. It took us about 2 years to get the amendment done and to deal with the multiple myriad of opinions. And if you look on page 22 and 23 of the act and look at the rules and regs for exempting a geographical area, you will see that it requires, I think, 100 acres minimum, the consent of half the people living in it, a whole series of procedures, a vote by town meeting, a vote by the community, just a whole series of processes to go through in order to make the exemption. And the reason was the original purpose of the district was to protect the north side of Cape Cod from the Mid-Cape Highway to the bay, okay? And everybody knew there is a large amount of land that's going to be developed, that you have tract subdivisions, you have all kinds of things where people are carving the property up, selling it off. And the feeling of the commission when we created this thing was we want to have a blanket of clarity. If you, at this point, look at your town zoning bylaw, how chopped up it is, and trying to figure out where's that line fall for the business zone, where's it stand for the residential zone, and the difficulty of being in one district versus another district. And also the concept of protecting this large geographical area which is rural. It's not a streetscape. It's not just one small area like most of your historic districts. It covers a vast area of 80 square miles, all the way from the canal to Eastham, and it is designed to set a particular area as requiring special architectural review, okay? When you sit, as you do on these committees, and you look at the enumerated factors that you are to consider in making a judgment of appropriateness, historic value and significance is only one of those 6 or 7 factors. The intent is to be an architectural review board. It is not to be just a historic preservation entity. And in fact, contemporary architecture is approvable, just as the I-4 building here in Yarmouth, or other changes that come in the type of material, that come in the type of architecture. And a way to perhaps grasp this is think about architecture. Architecture is a living art. It is something that's always changing. And what may be inappropriate today may be very appropriate tomorrow, and vice versa. So that you have to have that flexibility to change. In many historic districts like Sturbridge Village and a lot of these others, they have a particular agenda to preserve, let's say, 1850, or they preserve 1900, or they preserve a particular period in time. Our district goes 400 years of time, and different architecture, has every kind of architecture that has occurred. And this probably will sound kind of wacky. The ranch subdivisions of the 50s, 60s, and 70s, the one-story classic ranch, cookie cutter, is now more than 50 years old, will be more than 75 years, is a type of architecture that was constructed at that time when people were coming to retire to the Cape. They wanted everything on one floor, and they wanted the simplicity, and the developers were throwing up these structures, and that was what happened. However, it is there, and it may sometime be presumed, just as those little cottages down on the waterfront are considered to have historic value and reflect what people used to have when they came to the Cape as a tourist for the summertime or whatever. And yes, there is an ongoing process of demolition and putting up McMansions and all those different things. And now we've just had the legislature enact a bill that allows a second home site on a lot. And so you've got all kinds of change coming. And the concept of taking a large chunk out of the district and saying, well, we're not going to have public hearings anymore, and we're not going to do it, we're going to totally exempt it, and then change the district so it'll just be Route 6A, or the Old Kings Highway. And, well, I guess we can take this piece out and that piece out, and gee, these people are tired of the regulations, so let's get rid of it. You start a ball rolling, and it doesn't come back. In other words, once you let go of the geographical area that you presently regulate, it'll be extremely difficult, if not impossible, to reimpose the regulations on that part of the district. In Brewster, there have been many debates over that since they did it, and as yet nothing has re-included, and there are very historic properties that were cut out when they said, well, we're just going to cut it back to this piece or that. And the dilemma and the challenge to try to do that takes an awful lot of time, because in fairness to those people who live in the district, who go through the process of approval and say, oh, goody, now I'm in the historic district, I don't have to worry about that tin house coming on my neighbor's property, or whatever may be considered in the future. You basically need to step back and say, okay, these restrictions enhance the value of the property, and they protect the value of the owner who owns property in a historic district. And statistically, it's been proven when you put a historic district of regulation in place, the value of the property goes up because people want the protection. And in the same way, if you go to a gated community, or you go somewhere where there are private restrictions that protect the quality of the houses that are being built in a subdivision or in an area, it is that kind of value that, yes, it's sort of intangible, but it also is extremely valuable to the community, because in our situation, new development goes through a hearing process. The immediate neighbor gets notice that their neighbor's going to go out and do something with their property and has an opportunity to be heard. That's a great privilege versus, okay, well, if it meets the building code, meets zoning, they can do whatever they want. That's the logic behind the district as it exists, and why in Yarmouth you have all these areas, even though you may look at some of them and say, well, gee, that's commercial, that's industrial, whatever it may be. But the reality is you still have the protection of review and saying, well, you know, this should be toned down a little bit. Maybe there should be screening, maybe there should be this, that, and the other thing. And so the concept of geographical exclusion is something that has thus far been rejected outside of the Brewster experience.
So, yes?
I have a question that I'd love to have Jim address if we have time. And that has to do with enforcement. Enforcement the way it's supposed to work. Enforcement if it doesn't work that way, how you get it to work.
Okay.
There's so many questions around enforcement, like if someone never submits a certificate and you notice it and you say, hey, you never submitted a certificate, they get a violation letter. There's so many issues around enforcement that I don't think are happening properly, and I just wondered what your thoughts are on that.
Okay. The way it's been handled, and it has obviously been an issue, a public issue, as well as frustrations for committees. And it goes to the core. First off, our act does not give enforcement responsibility to the committees. The committees, as I've said in a lot of meetings, the committee is judicial, not administratively. You are charged with judging what goes up in the district, what gets torn down, what happens, but you don't have the power to go out and prosecute a violation. And in fact, there was a case, not in our district, but in another district, where a judge actually ruled that the violation of the act cannot be a basis for denying a certificate of appropriateness. That is, if somebody is in violation, they come to you for approval of a modification to their house. It could be whether it was the subject matter of not getting the original permit but coming in for it, or a different feature on it, that the judge ruled, and I believe correctly so, because it went to the appeals court, that the determination of appropriateness is all about the factors in Section 10. It is not personal. That when you're judging appropriateness, you're judging a building or a structure, not the individual that's applying for it. People come and go, owners come and go, but the building stays. And so when you're judging, you should not use the fact that the applicant is in violation of the act, either with the particular project or with some other project. You can't take revenge or try to extort from them that, because your judgment of appropriateness should be based on what it is what is the structure. You're judging a structure, not the person that owns it. And that's just the way we've tried to apply it.
We have just a few more minutes.
God, I
Any
talked
other
too much
questions
again.
from the committee?
Jim, there was some irony when you were talking about the demolition case where the building inspector and the committee differed, in that the building inspector is wearing two hats then.
Well, he has a building code, and also there's,
Our enforcement officer.
yes, he is. But he has to be your enforcing officer because he has the stick. That is, this act is truly based on getting a building permit, and it says you can't have one until you come through your committee first. But more importantly, getting a CO, certificate of occupancy, at the end of construction. So the building commissioner has a lot of power and control over what gets built and whether it is in compliance with what was approved, okay? And the power that the building commissioner has in that enforcing, I often call him the policeman for the district. That is, the building commissioner serves that role of enforcing the law. And you are the law to the extent of certificates of appropriateness. Also, there is a case that went to the Supreme Court in which the court ruled that while you don't have the enforcing power, you have the power to interpret your certificate of appropriateness as to whether or not the building complies. not the building commissioner. Okay? That the authority to issue a certificate of appropriateness and whether or not a certificate of appropriateness that has been issued has been followed, you get into the legal aspects of it in court, and the court ruled that what happens is a building commissioner should ask the committee, is this in compliance with what you gave as a certificate of appropriateness? So the court sort of gave you that authority, even though you don't have the power to do the enforcement aspect. You don't have power over the building commissioner as such, but you do have power over your decisions to the extent. But the reality over the years, and I can assure you of this, it is critically important that all committees have a good relationship with their building commissioner, because the building commissioner does have discretion. He has the power to enforce the act, and working with the commissioner, he or she, is essential for smooth administration of the law and its application in each town. And you will see variations from time to time with changing of building commissioners or philosophies or whatever.
So what is the process that the building commissioner is supposed to take? Once, we have 12 items on our agenda tonight. Is he supposed to go and follow up on every single one of those every time, or I know in theory what's supposed to happen and what reality people have time for, but what really is supposed to happen?
Well, what happens is usually there's a building permit issued for what you approve. And so presumably, they have to go out and do inspections on construction. And they do that to the extent that they have the manpower or the personnel to do it. And everybody's overworked, so you'll find from time to time that things get missed. Your role, though, at the best, is to advise the building commissioner of a potential violation, but in reality, I discourage you engaging in enforcement because it's not your job. And you get yourself into trouble when you do, because what happens is you then potentially prejudice your position when it comes back for reconsideration or for modification, because you've already declared yourself to be in opposition to what he has done or what has been done by filing a complaint. In other words, it creates an appearance of
Well, sometimes it's just a complaint
overreaching.
against the process or the lack of, sometimes it's just a complaint that they haven't followed the correct process.
The best way for it to work is when somebody comes to complain, you say, go complain to the building commissioner. He is the police chief in this case, and he is the person that can give you the remedy. It's not that you even should be going to the building commissioner and saying, hey, you're not doing this right. It's better to have the citizen that comes with the problem and say, okay, please take your complaint, send a letter, do whatever to the building commissioner and ask for enforcement.
So just on clarification on that point, so if it happens to be a member of this committee that observes a violation, we should pass that information on to a member of the public to communicate with the building commissioner?
No, that gets to, in that unique situation, and I say it's unique because you get, committee members get themselves in trouble when they start going out policing. That all you have to do is tell one owner, your sandwich board sign is illegal. You then set off a relationship between you and that owner that is not where you want to be, any more than a judge in the district courts wants to come out and enforce their orders and say, I ordered that you were supposed to do this or do that or vacate this or vacate that. That crosses the line of your role being a judge, an objective judge, rendering a decision. Judges can't enforce their orders. I mean, that's the way the system works.
So just-
They have police to do that.
So procedurally, Jim, let's say I
Yep.
happen to notice a violation.
Yep.
What do I do with that information specifically?
I would be very slow to go on the record with a complaint to the building commissioner. However, that's a judgment call.
Okay. Okay, got it. Anybody else? Thank you so much, both of you. Very, very informative, very valuable. We appreciate it.
Well, you guys do a great job, seriously. And over the years, Yarmouth has done a terrific job. Yes, you've had controversial issues, as we all have, and it is part of the job.
Thank you both again.
Thank you very much.
Thank you, thank you.
Yeah, that's probably good for now.
The gentleman's remark.
Have a pleasant rest of the day.
Thank you. You too.
Jim.
Yeah.
I'm not sure how to spell it, so, it's Vecchi. I'm not sure it's V-E-C-C-I, V-E-C-H-Y, something like that. I'm not sure. Something like that.
On the roster at Old Kings Jim's office?
I think she might be, I'm not sure. I've never met her before either, but she deals with all the appeals to the courts
Yeah.
of the Old Kings Highway stuff, so I don't think we've had any of those since I've been here. Yeah, I don't think some of the other towns may have had that, but yeah, I think that's what she does. But, yeah, I've never met her before either, so. Steve.
What are you doing to me with the whole crowd? I'm like, damn, I know it's 7:15. Dennis is 6, not you guys.
know, yeah.
I don't know if I told you the last time that Greta got released.
Oh, no, I didn't know that. I'm
So,
sorry to hear
of course,
that.
She was the rock on the
Yeah,
whole
of
thing.
course, yeah.
And so things may be coming in
Okay.
a little differently.
Okay. Yeah, thanks for the heads up, I appreciate that. I'm sorry to hear that.
Yeah, me too. I worked with her 9
Yeah, I mean,
plus
she
years.
was on it. She said the check's in the mail, the check's in the mail.
Right.
You guys are the only ones I ever trusted with the checks in the mail. Okay, put you on the agenda, nobody else. 2 days later, here comes the check.
Yeah.
Yeah,
If
sorry to hear
It
that.
was the mail's fault,
Yeah,
not
exactly,
her.
exactly. It was nothing, it wasn't
And then I
her.
would drive down to Jack and give it
Right,
to you.
exactly, and it was fine, but, oh, I'm sorry to hear that, but I appreciate the heads up, but I'll look at the applications closer when they come in, just to make sure there's nothing missing and that we get everything that we want. Because again, that was something I never had to look at because she just,
Gonna-
you know,
right,
yeah.
The renderings that she did and
Yes,
everything
right,
else.
right,
So.
yeah, okay. Oh, I'm sorry to hear that. Thanks for the heads up, though, because I'll keep a better eye on those applications that come in from you guys since she's not there anymore.
Well, thanks. Although, put the fright in me. I'm like, well, I guess I'm here to the last one tonight because I'm first.
I thought the meeting had already started, and if you missed it, do you need some water?
Do we
Need some
have any
I'll
water?
I can get some.
Go
water.
for
Yeah,
it.
yeah, yeah.
Do you want some water?
Please.
Thank you. Want me to help you carry the
Well,
water?
I gotta find some cups first, so
Oh,
I
okay.
don't.
All right.
I'll
Thank
see what
you,
I can
Lisa.
find.
Me-
I'm going to share this with you. I forgot to bring mine. When the time comes.
Lisa told me that you sent over the piece of paper to her, yes, regarding the farm,
Oh, yeah.
the goat farm.
Yeah.
She didn't know anything about it until
She's
you
on
did.
it.
Yeah, yeah.
Thank you very much. Excellent.
Thank you. Thank you. Don't worry. Secret water supply.
Good evening, and welcome to this meeting of the Old Kings Highway Committee of the Town of Yarmouth, which is being held in accordance with Chapter 470 of the Acts of 1973 as amended at 7:15 PM on Monday, July 14th, 2025, at the Yarmouth Hall Hearing Room located at 1146 Route 28, South Yarmouth. Moreover, pursuant to Chapter 20 of the Acts of 2021, considering certain COVID-19 measures, this meeting is being run in hybrid mode, by which I mean there is obviously live participation. There will be undoubtedly some Zoom participation as well. 12 new applications for certificates of appropriateness will be heard this evening in the order listed on the agenda. Please be reminded that our committee's main purpose is to review items for appropriateness and setting, and it is the responsibility of the applicant to comply with the regulations of other town boards and departments, including building, conservation, engineering, health, zoning, and the sign inspector. You should know that there is a 10 calendar day appeal period starting once a decision is filed with the town clerk. Any person aggrieved by our decision tonight can appeal to the Regional Commission of the Old Kings Highway Historic District. Our office administrator, Lisa Sherman, will be happy to answer any questions you may have regarding this process. So as some, possibly many of you, realize, our process here is to call each application in order as listed on the agenda, have the applicant and/or applicants, if present, come to the table in front of me, speak into the microphone, identify yourself or yourselves, and state your case without interruption from members of the committee or the public. After which, I will ask the committee to make comments and/or ask questions, and following that, members of the public will be free to make comments and/or ask questions. And for that purpose, if present, if you would kindly stand to the podium, to my front left, speak into the microphone, identify yourself, where you live, and state your piece. So having said all of that, we'll proceed with the first item on the agenda, which is 25-A087. It's to install 38 solar panels on the front, side, and rear roofs at 138 Setauket Road. Narvel Marks is the owner, and Sunrun Installation Services is the agent, and I recognize the agent.
Good evening. I'm Steve Kelly with the Sunrun, and I'm here to discuss our project. We're going to propose 38 total panels, 28 of which are on the front of the house facing Setauket. One of them sort of faces sideways, but they are visible from the street. We have 3 arrays that are symmetric. I don't want to say rectangular, but they're squared off. The shingle color is not a black, but it is a almost a dark slate. So that is a factor also. And the house was built in 1986. That's all I have.
Thank you, Steve. Questions or comments from the committee?
Steve, is that the original roof?
I can't imagine it is 1986. I didn't get up close to look at it. That roof would be 40 years old.
Not likely original.
It's not likely to be original. And 1986 might have been architectural shingles, but they were probably a 3-tab.
It's obviously prominently visible from Setauket Road.
It is quite visible. We had a project across the street that hasn't been built yet. I don't know why, but it is definitely. No hiding that.
And as I look at the site plan, I have the overlay of the tax parcels on Google Earth imagery, and it looks like there's maybe adequate space behind the house to do ground-mounted panels. Was that ever considered?
It probably has not been considered for a variety of reasons. We prefer the roof-mounted systems to the ground mounts. We tend to have zoning issues and setback issues and things like that. I don't think it backs up to the power lines. I think it's a little bit further down Setauket to have that. But I don't have a good answer for looking at it for a ground mount.
Well, in terms of setbacks, generators are allowed as long as they're not within 5 feet of a property line. Solar panels are much quieter than generators. So I suspect if there were a setback, it would probably be 5 feet.
I respectfully disagree. I don't know, but generally, we find it to be a minimum of 20 up to 50 feet for a ground mount.
Do we know if that's the case in Yarmouth?
I do not. No, that's why I'm disagreeing with the little knowledge that I have of the,
Well, we're both at a disadvantage there in that we don't know what the setback is.
correct. I would be extremely surprised if it were 5 feet. That I will say.
Would appear that the orientation of the house is conducive to solar panels on the front roof, but not ideal. House appears to be set so that it's facing, the front roof is facing southwest. I don't know, in respect to true solar south, what, you might know better than I, what that translates to.
That appears to be the orientation southwest. So, ideally it's south, but,
You're close,
right.
okay.
I mean, sorry.
Go ahead.
I was just going to say that my only concern is that the roof is a lighter gray color, so they are a little bit more visible than if it was a dark charcoal gray or black.
Yeah, it is not a black roof.
Is the back part of that roof a dormer? Is the back of the house a dormer that would bring that back roof higher? It looked from the side that it was a dormer, which would make the roof flatter on the back.
It probably is a dormer, just looking at the penetrations. Of course, typically they put all the vent pipes up the back. It looks pretty cut up back there, so I don't think we could get many, if any, more panels there.
So all those little red dots are pipes?
Pipes or vents, obstructions.
And plus, that's a northeast orientation, which is probably your least favorable.
Yes. And again, we need to have we do have some fire pathways there also.
So Setauket is a heavily trafficked artery, but it's not populated by antique houses. One could argue, I suppose, that in that regard, it's not a particularly historically sensitive part of the historic district.
I have a comment on that. I took Duncan Oliver's course on the history of Cape Cod, which unfortunately is no longer available. But one of the interesting things that Duncan pointed out is that Setauket Road follows the path that the early settlers and the Native Americans used to get from east to west without going through the marshes in Dennis and Yarmouth and so forth. And although it's not considered a historic route, it was prominently used in history.
Just to clarify what I stated it's not populated by antique houses.
Correct.
Not that it's not an historic artery. So you're quite correct on that.
Paula, that is a dormer on the back. It's 19-degree pitch.
That's what I thought, but if it's populated with vents and pipes, then there's not much you can do about it.
Yeah.
so.
Yeah, the house was built in 1986.
Any other questions or comments from the committee? Are there any questions or comments from the public, especially abutters? We have one.
Good evening, Liz Argo, Yarmouth. I live at 179 Setauket Road, and I have solar panels, as does my neighbor who's on Duck Pond Road, and the one that you approved recently that's at just past the corner of North Dennis Road. And we're glad to see them go in our neighborhood, right on Setauket. Thank you.
Thank you. Any other comments from the public? Hearing none, I'll entertain a motion on the application.
Move to approve application 25-A087.
Second.
It's been moved and seconded. All in favor kindly signify by saying aye.
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 Nay.
Okay, Steve. Thank you, sir.
Very much. We'll see you soon, I hope.
Okay.
It's been recalled.
The next item on the agenda is 25-A088. It's to replace the front siding at 385 Weir Road. Eileen Powers is the owner, and Roofing and Siding of Cape Cod and Boston is the agent. And do we have either Eileen or the agent present? Or online?
Yep, there's online, Bob. Yep, hang on a second.
Hello.
Yes.
Hi, my name's Scott. I'm with Roofing and Siding at Cape Cod.
Okay. Present your
So-
application.
Yes, so we're proposing to remove the original pine clapboard that's on the front of the home now and install a hardy clapboard in the front. I know we did drop off some samples with the color as well, I believe.
That's it.
We have them.
Top one.
So, I guess these are the same.
Other side.
Oh,
This is something else.
129.
Okay.
must be a different one. That's for a different
Are
house.
are they different?
Yeah, so, Deep Ocean. And what is this for? This is for this one. No, just the front of the house.
It's just wait.
Is it?
So it's the other one.
That's 385
Yeah.
Weir Road.
Yes, that's the color.
That's the address and that's the colour.
Okay, all right.
It's the darker one.
So it's the darker one. We have two samples
Yeah,
here.
we'll get the chairman there in a minute.
I believe it's the dark one, yes.
Yeah.
So you can see it's pretty similar in texture to wood.
Okay. Is that it?
That's it.
Okey doke. Questions or comments from the committee?
Hi, I'm sorry, I didn't get your name.
My name's Scott, sorry.
Hi, Scott, thank you. Scott, the picture in the application, is that the front of the house, the facade that you're proposing to put the hardy plank on?
I believe it is, yes.
So what color would the trim be with that midnight, what is it called? Midnight ocean, sorry,
So-
deep ocean.
So the trim will remain exactly the same. I don't know if she's planning on painting it at a later time.
So, looking at this picture, that facade is what I would call like a dark taupe color. And it looks like the trim on the first floor is white. The trim on the second floor is the taupe. So I'm just wondering if it would all be the same color or sort of a combination of two colors currently.
I know she's already had some work done where it's been switched over to the PVC trim, and I believe they're painting that afterwards.
So is the intention to make it all white?
I believe the intention is to make it match the same color that's on the top now. That's
Okay. Even with the dark deep ocean siding.
correct.
Other questions or comments from the committee? Questions or comments from the public, especially abutters? Hearing none, I'll entertain a motion on this application.
I move to approve application 25A088.
Second.
Can we have further discussion on that?
Yes, sure.
So I have no problem with the hardy board, but I really don't like the two different colored trims, and I think, I shouldn't say like, I'm sorry. I think it would look better with the trim consistent color to match the trim around the windows, which is white, particularly with this deep, deep blue. I think the taupe color and the deep blue are gonna, I don't think it's gonna be very complementary. I personally would like to see the trim all white. I don't know if that's how the rest of the committee feels about that. Or if you want to make
Actually,
that.
not part of the application. They're only talking about the siding.
Right,
So I don't really know that
we can do that.
we need to address it.
Okay.
Something for the homeowner to consider, though. I think it's a valid observation.
Well, didn't he say he thought the homeowner's going to make them all white?
No, he said they're going to match this color on the trim.
The hell, look, that's on the house now?
I mean, I'm assuming, so I don't know what their intention is on their trim.
All right, well, as said, it isn't part of the application, so it's not our call.
If it's something other than white, wouldn't they have to come before the committee?
Right, what if they painted the existing color that it is now, if they keep it the same color, they can do that, which is like that taupe color.
Looks white to me, but
Look at the second floor, John, the gable end. Gable end, the second floor. It's the trim on the rake boards and the sideboards are the taupe
I'm
color.
looking at the window.
I was looking at the trim, sideboards and rake boards.
Yeah, I wasn't looking at that either, I was just looking at the
Talking
windows.
See the white in the bottom,
Window or the,
taupe up here.
Yeah, I saw that.
I'm talking about all of the trim.
Okay, something for the homeowner to
It's not in
consider,
the
not
application, as Bob points out, so I
not
will.
something for us to consider. Any questions or comments from the public or especially
We always have a motion in a
abutters?
second, so.
All right. All in
Sorry.
favor signify by saying aye.
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 And aye. Congratulations.
Thank you.
John, sign.
All right. Sorry, John.
The next item on the agenda is 25-A090. It's to install a shed at 14 Hillsea Road. Brian Hardy is the owner. Pine Harbor Pine Products is the agent.
Jamie McGrath from Pine Harbor Wood Products, representing Mr. Hardy, who's also here if need be, proposing to build a 12 by 16 storage utility building at 14 Hillsea Road. Building's equal pitch, 10-12 roof pitch, dipped cedar shingles that would match the house. The house windows are black with simulated divided lights. The shed will also have black simulated divided light windows. Actual roof shingles to match and color weathered wood, if I'm not wrong. Yep, weatherwood roof shingles, Cape Cod gray, as I said, pre-stained white cedar shingles on all 4 walls. Doing a little bit of minor excavation there to flatten out the area and put the shed up. Any questions?
Okay, do we have any questions or comments?
I should say Hillsea is a little small kind of cul-de-sac dead-end road down there in the Yarmouth ports.
I know it well. I live in the neighborhood.
So is the roof color on the shed going to match the house roof color? Thank you.
Other questions or comments from the committee?
Looks very proper.
No shit.
Questions or comments from the public, especially abutters? I happen to know one abutter who's quite pleased with the project. Talked to her today. So I'll entertain a motion on this application.
I move to approve application 25-A090.
I second it.
It's been moved and seconded. All in favor signify by saying aye.
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 And aye. Congratulations. And if you'd sign this document, just in case you want to change anything, you'll let us know. Right there. You're all set. Good luck with it. The next item on the agenda is 25-A091. It's to install new siding, roof, trim, gutters, and skylights, and replace windows, a slider, and the front door at 42 Mill Lane. Wayne and Karen Roberts are the owners, and Cape Property Pros is the agent. Do we have either of the owners or the agent present?
He's on Zoom.
Yes, good evening.
Oh.
My name is Boris Jovanov. I'm the agent and also the contractor.
Great. Tell us about your application.
Yes, so we are proposing to do a full exterior remodel to the house, and we are going to be replacing the existing cedar shingles with Also cedar shingles, but they're going to be pre-painted with the safari beige color. Replace all the trim on the exterior, and it's going to be white as existing. It's just going to be the AZAC product instead of wood. The roof is going to be the black charcoal color, Landmark Pro's Certainty brand. And the gutters are going to be just the regular Cape Cod gutters that we see everywhere. The front door is going to be black, as presented on the picture. And also a storm door of full view glass with no grills. All the windows we are also going to replace, and they're going to have exactly the same pattern as existing with the grill pattern. And then the skylights are existing also, we're just doing like for the skylights.
Is that it?
That's about it, unless I'm missing something, but that's about it.
Great. Questions or comments from the committee?
I think you did a nice job in the application. It's pretty thorough.
Thank you.
Any other questions or comments from the committee? Apparently not. Questions or comments from the public, especially abutters? Big project. All right, hearing none, I'll entertain a motion on this big project.
I move to approve application 25-A091.
Second.
It's been moved and seconded. All in favor signify by saying aye.
Aye. Aye.
Aye.
Aye.
And aye. Congratulations, very thorough job.
Thank you very much.
The next item on the agenda is 25-A092. It's to install a shed at 117 Nottingham Drive. Jeff Humber and Barbara Saxon are the owners. Reed's Ferry Sheds is the agent.
Hi, thank you for having us. My name's Jeff Humber. My wife and Barbara, as you said, are owners of 117 Nottingham. We propose to install a 14 by 12 shed made by Reed's Ferry at the rear of our house, totally invisible from the street. The shed itself will consist of the 14-foot side of the building will have a 5-foot double door in the center, 2 windows on each side with black shutters. We'll have a window on the back of the building. It will be a vinyl building. The vinyl will be exactly the same color as our house. And it will require the installation of a ground, leveling a base.
A slab?
To put the thing on. And we have that already designated in the backyard, and it will be logs going across, tied together with gravel or some equivalent to gravel in between. But like I said, it's impossible, will be impossible to see it from the front of the street on Nottingham.
Questions or comments from the committee?
Beautifully hidden,
I'm sorry?
beautifully hidden.
Yeah.
How will we know it's done?
I'll send you a picture.
Thank you.
The tree falls in a forest and no one hears it?
Yeah.
Did it really fall?
Iowa
Okay.
wolves.
Any other questions or comments from the committee? Questions or comments from the public, especially abutters? Hearing none, I'll entertain a motion on this application.
Move to approve application 25-A092. Second.
Moved and seconded. All in favor signify by saying aye.
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 And aye. Congratulations.
Oh, sorry, John.
If you'd be so kind as to sign this
Sure.
document in case you decide to move the shed, make it plainly visible, increase the
Put it on
size
your
by
front
twice,
lawn.
or any other changes.
Make it pink. Put a pink roof on it.
It's a lovely area. That house that's way
Thank
up
you.
on the hill there that has all
Good luck
that
with it.
grass. Oh, my God, it's gonna be 2 acres, 3 acres.
You're all set.
I didn't realize you could, Kingsway Golf Course came out right out there.
The next item on the agenda is 25-A093. It's to paint the front and back doors at 1021 West Yarmouth Road. Stephanie Lavandowski is the owner, and Stewart Painting is the agent.
Hi, I'm Stephanie Lewandowski,
Aye.
owner of 1021 West Yarmouth Road.
Hi.
Hello. And I'd like to paint my door. So,
Okay.
Stella,
no,
That's
that's
what it
the
is.
is that the
existing door.
existing?
Yes, that's what she wants to do.
Look different. I don't think I have that. though. I didn't think so, but anyway.
Okay, questions or comments from the committee?
Nice color.
It's gonna take a few coats to cover up that red, though. It's gonna take a few coats to cover up that red.
Oh, yeah, well, I don't have to worry about that.
Okay.
Originally called Nantucket Fog, but Benjamin Moore, I guess, decided it had to update the name.
So silly question, but I assume you're painting both doors the same color?
Yeah.
There you go. Okay.
Any other questions or comments from the committee? How about from the public, especially abutters? Oh, yes, sir. Would you come up, speak to the microphone? You can use that one.
Okay. Sterling Kelly, and a butter of Stephanie's. We have no problem with the color change and very much like it.
Thank you.
All right. Thank you, sir.
You're welcome.
Okay. Any other questions or comments? Hearing none, I will entertain a motion on this application.
I move to approve application 25-A093.
Second.
It's been moved and seconded. All in favor signify by saying aye.
Aye. Aye.
Aye.
Aye.
And aye. So, if either one of you would be so kind as to come up and sign this in case you decide on a color change, you'll let us know.
You like this color?
Very much. I think we just said yes. So, actually, we're not supposed to make a subjective judgment, but yes. You are all set.
Okay, as soon as I finish reading that one.
No, you can, it's fine.
Lefty.
Another lefty. Another southpaw. Thank you. Just let us know if you're going to paint it
Good
purple
night.
instead.
The next item on the agenda is 25-A094. It's to replace the garage door with 2 windows and siding to match the current facade, wall in rear garage entryway, and replace 13 windows at 19 Covey Drive. Michael Thonis is the owner, and C.A. Vincent is the agent. Do we have either Michael or a
On Zoom.
representative of C.A. Vincent?
On Zoom, I think.
Yes,
Okay.
I'm Michael Tonis, owner of 19 Covey Drive.
Tell us about
We
your
are,
application.
Sure. So we're changing our garage over to a much needed dining room, and taking the opportunity to also replace the windows to keep everything consistent. So by removing the garage, we'll be adding 2 windows in its place, and matching the current clapboard siding. with color and all that. And then replacing the existing aluminum framed windows with Window World Series 4000 vinyl windows. And to mitigate glass loss, we're electing not to do grids.
Is that it, Michael?
Yes, sir.
Okay. Thank you. Questions or comments from the committee?
Are the two windows in the garage that you're going to remove, are they going to be, is that a casement, or are they going to be two separate ones that are going to be separated? How are those two windows
They
going?
will-
Go ahead.
I'm not familiar with the actual terminology and how they will be, but if you look at the front existing windows to the right of the door, there's two windows that are directly next to each other. So we would copy that design over.
Okay. And then will there be shutters as well?
Yes, we will also source the same look and color.
Okay.
So the existing shutters are they red?
Yeah, a maroon color. Yeah.
So sometimes it's really helpful to see the proposed change, like if you showed us the garage with a diagram of where the windows are going, it's really helpful for us to visualize.
In the documentation, I did put an area marking out the
Right,
garage
but-
and then
Right, you showed the existing garage door with numbers of where the windows were going to go, but it doesn't show what it's going to look like, which is helpful for us to see a sketch or something of what they're going to look like. Just commenting.
Thank you.
So the trim color, what's the trim color, please? Michael.
It's the trim color is currently blue. We would have the new trim color match the current blue color.
Okay.
I'm looking at a diagram here that shows the layout of the interior of the house. And it shows the garage, and it shows what looks like to be a three-window casement in, not two windows, unless that is the existing garage door. I can't tell. To her point, it is so much nicer to see a finished design for what you plan to do. But do you see this, what I'm talking about here?
Hard to know what it is from that.
It doesn't
floor
look
plan.
like two windows. To me, it looks like a casement.
Well, it looks like the one in the
I
living
believe that's
room.
the front. You know, it's intended to be centered up in the opening of the.
Yeah, it actually
garage.
looks exactly like the window in the living room.
On the left, to the left of the door, not to the right of the door.
Not that it matters really, but
Be nice to know what they're doing, so.
Right. We can have C.A. Vincent make sure that they'll confer with the building department for proper spacing of studs and whatnot, but there will be two windows there, not three.
that will match the others.
Correct.
Okay.
You'll match number 4 and 5 on your front elevation.
Yes.
Well, it's in the back of the house, so
Garages?
not going to be visible from Covey.
The garage is in the front of the house.
Garage in the front of the house.
There's maybe what you're seeing is there's an exit door in the back of the garage that we will
All
also
right,
wall
yeah,
in.
thank
That's
you.
right there.
You're right.
Okay.
You're also saying replace existing windows.
Correct. There are currently 13 windows in the house. They're all original from 1986, and they need replaced quite badly. They
Those
don't
win-
hold in any kind of heat or hold out the heat in the summer or hold it in the winter.
Now, those windows are all 9/9 grills, and you're proposing to replace them with no grills?
Correct, as consistent with other houses abutting the 23 Covey Drive and 24 Covey Drive.
The house was built in 1986, according to your
Correct.
application. Michael?
Yes, 1986, that's what the documents tell me.
Okay. Other questions or comments from the committee? Questions or comments from the public, especially abutters? Hearing none, I will entertain a motion on this application.
Move to approve application 25-A094.
I'll second.
It's been moved and seconded. All in favor signify by saying aye.
Aye.
Aye. John?
Aye.
Aye.
Oh. Whew. Okay. Congratulations.
Thank you.
I think it's confusing question.
The next item on the agenda is 95-A096, 95. It's to replace siding at 24 Perch Pond Way. Sharon Brigham is the owner, and Roofing and Siding of Cape Cod and Boston is the agent.
Hi, this is Scott with Roofing and Siding in Cape Cod.
Okay, Scott, we're ready.
All right, so what we have right now is we have a vertical tongue and groove board that's around the entire house, which is damaged pretty badly from woodpeckers and some rot. We're proposing to remove all of that and install a cedar impression vinyl that looks like wood shingles on the entire building.
Okay. Is that it?
That's it.
Questions or comments from the committee?
What color trim do you plan?
So she wants to match with the siding, so it's going to be the same color as the siding, which is a little bit darker than what she has now.
So all trim around windows and doors as well?
That is correct.
And Perch Pond is a dead-end road, and you're at the end?
Correct.
Okay. Any other questions or comments from the committee? Questions or comments from the public, especially abutters? Hearing none, I will entertain a motion on this application.
Move to approve application 25-A095.
I'll second.
It's been moved and seconded. All in favor kindly signify by saying aye.
Aye. Aye.
Aye.
Aye.
And aye. You're all set.
Great. Thank you very much.
You're welcome. The next item on the agenda is 25-A096. It's to install 26 solar panels on the rear roof at 178 Eileen Street. Dylan Vaughn is the owner. Katuitt Solar LLC is the agent.
Hi, good evening. My name is Leah. I'm with Katuitt Solar, representing the homeowner, Mr. Vaughn. Our plan is to install 26 black-on-black solar panels on the back roof, which is not visible from the road, and it also borders power lines in the backyard. There is a nearby house. There's a picture that I included in the application on 30 Outward Reach that intersects with Eileen Street that has solar panels on the front of the roof that are visible from the road. So we're hoping that this would be approved since it's the back of the house facing power lines.
Is that it?
That's it.
Okay.
Thank you.
Questions or comments from the committee?
I'm curious how old the roof is.
I know, yeah, I heard you ask that with the first question, with the first group. The house was built in 1981. I'd be hesitant to think that it's the original, but I could find out.
I'm just wondering if, they don't, it's up to them if they want to put solar panels on an old roof and then have to go and take them off to
Right.
replace it would be a real pain.
Yeah, we have our roofing specialist look at the integrity of the shingles before we install.
Thank you.
Yeah.
So it's at the end of a dead end. And although it's visible from Outward Reach, you'd have to be either walking the railroad tracks or riding the train to really see them prominently. Any questions or comments from the committee otherwise? Questions or comments from abutters or other interested members of the public? Hearing none, I will entertain a motion on this application.
I move to approve application 25-A096.
Second.
It's been moved and seconded. All in favor signify by saying aye.
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 Aye. Aye.
And aye.
Thank you.
So if you'll sign this, in case you are going to change it in any way, you'll let us know. Good night.
Thank you.
The next item on the agenda is 25-A097. It's to add dormers and replace windows, siding, and roof at 129 Driftwood Lane. W.T. Chatham LLC is the owner, and Michael Thiel is the agent. And who do we have?
I'm Mike Thiel. I'm the owner, and that house is sad. We just bought the property, and the house has sat vacant for a couple of years. They had a small little fire in it, and we'd like to replace the roof, add 3 dormers across the front, all new windows, siding, trim. We have the samples up there. And the inside of the house will be fully remodeled.
No, Driftwood.
Has been or?
No, well, it will be once
this also. Okay. Do you, John, want to see it? Is that it?
Huge house.
Yeah, it's a good-sized house.
Questions or comments from the committee?
Yeah, I'd like to see where the dormers are gonna go and what they're gonna look like.
You have all the blueprints that I sent with the,
I only see photographs. Ah. Okay, thank you. That's helpful. Okay, so that's the front, yes?
There's a question on the windows. In your write-up, you say 6/6,
yes.
and the plans show,
Well, they'll match they're Anderson 400 series windows to match the existing ones that are on the house.
the plan shows.
Some are, well, but some are different. Some are bigger than the others. Second floor in the back will have smaller, there's awning windows on the back that will have just 4 grids.
There's another elevation on this page.
So are you changing the pitch of the roof, or the roof, it's staying the
No,
same?
no, we're just adding dormers to the,
It looks steeper on this. Maybe
No.
it's just the way it's drawn.
no, the roof stays the same. We're just adding the dormers on it.
You see this? Yeah, actually. There's 3 dormers. 2 doghouse, and you tuck it. Is the door getting moved?
The front door?
Yeah.
No. It just has a little overhang over the front.
So you're adding that?
Yes.
Oh, yeah, okay. It's
It
behind.
just has a small roof.
Behind the tree.
Yeah. It's, it just has a small overhang over it.
You're not doing anything to the garage?
No, just changing the garage doors.
Okay.
I mean, they'll be the same, but they're all dented right now. The garage stays the same. Well, exterior stays the same, just take everything off and put everything new on. White AZAC trim, the gray Hardy on the front, and white cedar on the other 3 sides. And a new asphalt roof.
The gray hardy
Yep.
color.
It'll be the charcoal roof.
And I see a discrepancy between the plans and the photos.
Which part?
On the photo of the rear of the house, windows on the lower level are 6/6. On the plan, they're shown as 4/1s.
Oh, maybe that's just a mistake on the plan. But they'll be all, you have the whole list of all the windows that are there, that are from Anderson? So that's what,
They'll all be the same as the
Yes.
existing windows.
Yes, the plans.
Oh, sure. Sorry.
John, you may want to.
This is the roof color, charcoal. Hardy color for the front.
Yeah, that's what I was looking at in the smaller version.
And which is the color you've chosen for the?
Charcoal.
The charcoal.
and then the light gray Hardy for the front clapboard. And all the trim is AZAC.
So you said removing the deck in the rear, is that all
That
going away? Is
Screen
that
porch
all-
stays, but
that all goes away?
deck there on the side and on the back, it's only like 7 feet wide, 8, it's all, so I'll just have a set of stairs from the screen porch, and then on the back, there'll be a landing with a set of stairs to a patio.
Okay.
But that old deck comes off. It's no use for it, it's too narrow.
Did you say you're taking down the whole deck along the side and the back?
Yeah, it's, like I said, it's only it's more of a catwalk. It's like 6, 7 feet wide, and it just wraps the corner. But the screen porch on the side will stay, but it will be rebuilt. New screen, all new AZAC trim, roof.
Be nice.
Extensive landscaping there, too.
Any questions or comments from the committee on this? Other than what's already been asked? Questions or comments from the public, abutters, or anyone else? Hearing none, I'll entertain a motion on this application.
Move to approve application 25-A097.
Second.
It's been moved and seconded. All in favor of approval signify by saying aye.
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 And aye. Congratulations.
Thank
Well
you.
done. In case you decide to change anything, you'll let us know, please. Here. Good luck with it.
Thank you very much.
You're welcome.
Welcome.
You too.
Good night.
The next item on the agenda is to replace and expand the deck at 1 Duck Pond Road. Kevin Quinlivan is the owner, and PLJ Carpentry, Inc. is the agent.
All right, good evening, everyone. My name is Roberto. I'm the manager on PLJ Carpentry. Tonight, I want to propose for Mr. Kevin that we're going to extend, of course, replacing all decking boards, keeping the frame, the existing framing, install new decking boards with a composite wall decking, harbor gray color, and PVC railing around the whole deck, keeping like the same style as it is right now.
gonna double the size of it?
Yeah, well, no, yeah, actually it is. We're gonna add a 10 by 20 new frame. We're gonna install and attach that to the old framing and extend the whole area. I don't know if you guys have the pictures on the contract that I sent it. As you can see, I don't know. Oh, you guys have that. Awesome. And I also brought the 3D design here. I don't know, probably you guys have that on file as well, but like I said, we're gonna just extend it, and in my perspective, I don't think that it's visible from the street, but
It is visible from the street.
from
but
the
it's
other one, right, because it's on the corner.
Right on West Yarmouth, you can see it, but
Pine.
it's
Yeah.
not an issue.
Pine Street, Paula.
Yeah, for Pine Street.
Oh, Pine.
Yeah, it's visible from the, let me see, I do have that here.
The deck is visible from Pine Street.
Yeah, probably it is.
Yeah, and it's being expanded in the direction of Pine Street.
Yeah, it is visible from Pine Street. But also, like I said, we're gonna keep the same layout as it, not layout, same perspective, I say, I don't know, because they already have gray deckings, wide railings, and PVC around the whole thing, so it is gonna be just, of course, expanded.
So it'll all be on one level, and the
Yeah.
railing will be exactly consistent with what's already there.
Exactly. Same style, same.
I'm just curious, I've never seen PVC, is it like a Trex material, done with blind fasteners? Is that how you guys typically do them?
I didn't get it.
With
Can
the
you say again?
blind fasteners?
We use edge clips. I don't know if you have seen those before. Every decking board has like a tuning groove in between them.
Okay.
And we install 2 decking boards on, right next to it, and they have it looks like a U-shape metal flange that we install in between the decking boards, and we screw that into the frame.
So it goes into the tongue and groove
Yeah.
slots?
Just on the picture frame, we use screws and plugs, because I like to do something
Okay,
a little
thank
bit
you.
modern. Yeah.
Other questions or comments from the committee? Questions or comments from the public, especially abutters? Hearing none, I'll entertain a motion on this application.
Move to approve application 25-A098.
97. I'll second. Oh,
did you
98,
second?
sorry. I missed one. You seconded it.
I just said it. Second.
Been moved and seconded. All in favor signify by saying aye.
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 And aye. So congratulations and good luck with it. And if you're going to make any changes, you'll come up and sign this document, please.
Absolutely.
Let
Thanks
us
so
know
much,
that
everyone.
You've decided on something else or some modification.
I'm actually more interested in what's in the garage.
Absolutely. Yeah.
They have something?
You know what I'm saying? Those 2 beauties in the garage?
Oh, I haven't seen it. They
Oh,
have
yeah.
something?
No, he's got 2 vets.
Oh, really? So we'll do it right here.
Yes, right there. Good luck.
Ooh, and a red vet.
Thank you.
Night. All right.
present first?
Oh.
Read the letters.
Let him present first. It's like a butters.
That's why I asked you.
Butters commentary, yeah. Let them present first.
Okay. Next item on the agenda is 25-A099. It's to install 10 solar panels on the side and rear roofs at 55 Route 6A. Susan Starkey is the owner. Skyline Solar LLC is the agent.
How's it going? Thanks for having us. Jared, this is Thomas. We're acting as agents here this evening. So we are looking to install this system for the Starkeys, and since the beginning they've been very clear about the historic nature and the location of the home, and we took that into great consideration when we designed this project. There was a face of the roof that faced 6A that we avoided entirely to preserve that front nature of the home. The system is set to cover all of the home's electric use throughout the entire year, doing a complete offset. Also, being installed with this project is a new roof going to an all-black color so that it is a black-on-black appearance to, again, maintain that preservation and have it look as discreet as possible.
Is that it?
So.
Okay, well, there's been considerable public interest in this application, and we have received several letters regarding it, which I will now read into the record. First one is from Mary Robinson and Douglas Robinson, residing at 4 Church Street, Yarmouthport. It was sent to Lisa Sherman via email. Please forward this letter to the meeting on July 14th regarding solar panels. Dear Old Kings Highway Committee, solar panels at 55 6A will be visible on Route 6A/Willow Street and do not support the historic character and aesthetic of the scenic highway. We believe the panels can be installed as a ground array or roof installation in an area of the property that protects all views from 6A and Willow Street. Solar and preservation can work in tandem. Please find an alternative that does not affect the historical significance of the scenic highway. We are, as property owners on 6A, impacted by the decisions to change its character. And we received, again via email, from Sandra, I believe her name is pronounced Kuhfahl, Kuhfahl, and apologies to her if I pronounced the name incorrectly. I would appreciate my objection and denial of this application be read into the record. We realized when we moved to 6A in 2004 that there were rules in place to preserve the character of the historic district. We understand this committee has denied this application before. Solar panels would change the character of our town. When you purchase a home in this historic area, we all have to follow reasonable restrictions to preserve the character of our historic homes and surrounding properties. We object to this application and would like to see it denied. Sandra and Thomas, 418 Route 6A. Next one was addressed to myself, Bob Wilkins, Old Kings Highway Chair, and Lisa Sherman, Administrator. Since I have a conflict this evening, I ask that my letter be read at tonight's Old Kings Highway meeting. I am concerned about the 55 Route 6A Starkey reapplication for 4 solar panels visible from Willow Street. I find it astonishing that they feel that complete elimination of any fuel cost is somehow owed to them. Their willingness to comply with Old Kings Highway recommendations and instead use a denial as a, quote, test case, unquote, for more permissive solar panel standards flouts the interest of other homeowners in the historic area who respect the current Old Kings Highway standards for a historic district. They knew they had purchased in an historic district when they bought the house. I would suggest if they are completely wedded to total solar panel coverage, that they put their money where their mouth is and repair the accessory buildings on their property, which would easily conceal the additional panels they seek today. They are reluctant to install panels facing their neighbor, but instead find it acceptable that all who pass on Willow Street must enjoy the view. Allowing panels visible from Willow Street is a challenge to the local Old Kings Highway Committee, one which they and select person Liz Argo seem interested in undertaking so as to weaken its standards. As a Route 6A homeowner since 1997, I resent their sense of entitlement and encourage yet another denial of this application. Yarmouth's Old Kings Highway Committee has done a wonderful job in preserving Route 6A in the past, and I support the continuation of its current regulations. Signed, Dinah Wolf, 270 Route 6A, Yarmouth Port. And then another one, again via email. Good evening. As a current member of the Old Kings Highway Yarmouth, serving as an alternate and previously appointed by the Town of Yarmouth Select Board to the position of architect contractor, I would state my unwavering and continued objection to this application. The Old Kings Highway Board has previously denied an almost identical application for this address. It is my considered opinion that the solar panels being visible from either the Old Kings Highway or Willow Street are in direct contradiction to the rules and regulations set forth by the Old Kings Highway Regional Historic District Commission, Commonwealth of Massachusetts Law of 1973. The board is certainly given proper weight in considering applications in the historic district of rooftop solar panels. I would strongly urge the members of the board to deny this application as it is not proper in setting or place. Regards, John Stewart, 182 Route 6A, Yarmouth Port, Massachusetts. And then another email that was sent directly to me. The Revolutionary War Commemorative Committee has researched the participants in the war, and DY has over 400 confirmed combatants. Captain Joshua Gray was a neighbor on the corner of Wharf Lane of the Hallets. Later, the Reverend Lincoln lived in the Gray house, and his son, Edwin Hale Lincoln, went off to the Civil War as a drummer boy at the age of 14. The boy's uncle was responsible for Edwin during this time. Mr. Gray lived next door in what is now Ski Morton's home. So, Bob, you can see why there is opposition to visible solar panels along Route 6A. The history here begins with a pilgrim, Stephen Hopkins, to a Broadway icon, Edward Gorey, and beyond. This was sent by Maureen Ruxalis. Thank you. And in addition, dear Bob, it is my understanding that the owners of 55 Route 6A Yarmouth Port are once again hoping to get approval for solar panels from Old Kings Highway. Solar panels are not appropriate if visible in the historic district period. Number 55 was owned by Jacob Hallett and appears in the 1958 Whaling map. His property was bordered on the west by his father, Ezekiel Hallett, on the east by Jonathan and Ezekiel Hallett. Jacob's neighbor to his south was John Reed, who was a Massachusetts lieutenant governor in 1850. John Reed helped a number of Yarmouth's Revolutionary War veterans to appeal to the federal government to receive the pensions that were due them. A neighbor just west of Ezekiel Hallett was Eliphalet Edison, hope I pronounced that correctly, who was known for his cabinet making. The clock in the hall at the Brangs Hallett House is an example of his work. When someone is considering purchasing a home in a historic district, one must be aware of the history of the neighborhood. As the owner of a home on Old Kings Highway, we are conscious of the fact that we are caretakers of it and respect and maintain its facade. That should be everyone's mission. Respectfully, Maureen Ruxtalis, 381 Route 6A. This is the last one, I believe. To the chairman and members of the Old Kings Highway Historic District Committee, from Ellen Briggs, founder and president of Protect Our Past, a nonprofit organization. regarding 55 Route 6A, requests for solar panels on roofs facing 6A and Willow Street. The Greek Revival House located on 55 Route 6A in Yarmouthport is 155 years old and has been well kept with no major alterations. This deems it as an historical treasure of Yarmouthport, Cape Cod, and of the United States of America. Daniel Cole, a descendant of the original Cole family, who were some of the first settlers of Yarmouth, positioned this currently unspoiled historic house to sit high up for majestic stature visibility from both 6A and Willow Street. It sits there as living history to everyone who drives north and south on 6A or east and west on Willow Street to view. This is a busy intersection. Placing solar panels on the roof facing both 6A and Willow Streets will deface this historic icon. Try as one may to convince anyone otherwise, it is irresponsible. It is thoughtless to take the position that defacing an historic, irreplaceable treasure is permissible. Significant weight to houses related to history must be applied here. Once they are marred, their historic significance is lost forever. Protect Our Past asks you not to agree to allowing the current owners of this property to put solar panels on any portion of the house facing either Willow Street or 6A, AKA the Old Kings Highway. Thank you, gratefully, Ellen Briggs, founder, president, Protect Our Past. So, a lot of really profound feelings about this. And I'll ask for comments or questions from the committee at this point.
Can I ask, did I understand you to say that the 10 panels would provide everything the house needs by way of electricity?
Yes, that's the truth.
This may seem completely dumb, but why are 38 panels needed on Setauket?
I don't know.
It all goes into the usage of the home.
Do with the usage of the home?
Yeah, it's relative to how much electricity the house uses.
And it's a rental in the other case.
Sorry, I missed that, Liz. Can you...
Yes, with your permission, we'll let Ms. Argo comment at this point.
This is Liz Argo, Yarmouth resident. It's just because the other one is a rental. They are leasing those solar panels, and it makes the economics very, very different. So Sunrun and Katuitt Solar have an interest, but Sunrun in particular with the 38 panels, they have an interest in putting on more panels. So we're comparing apples to oranges. This is a very minimal installation just for their minimal electric use.
Thank you.
Also, being that this house was erected historically in 1830, and the square footage of this house is 1,732 square feet. This is not a large installation by any scope of what's happening. And to answer the question, there's not an original roof on that house. So the modernization, I understand, and I understand the feelings of many people in the community. But we're talking about a very small footprint of what's happening, and also the design itself was made to be able to hide or to be able to kind of blend it in the smallest footprint area. If you're looking at the pictures that we presented to you, it was not visible from 55A or from 6A. However, it would have been completely impossible to shade it from both Willow Street and both sides. So the minimal footprint on the back of the house, not oversizing the system, is addressing the need and the wishes of this installation.
I have a question. Panels, 6 panels on the L are not really visible from Willow Street. If you're looking for them, you can see them, but if you're not looking for them, you probably will not see them.
You'd have to be looking for them.
The 4 on the roof, on the rear roof of the house, adjacent to the skylight are prominently visible from Willow Street. You can't miss them because of elevation, and they just stand out. And it's on a gray roof now. It won't be as visible on a black roof, but it still will be visible. As I look at the aerial imagery of the property, it has a very large parking area, which is probably vestigial from when it was used for commercial purposes, and there was a couple of stores in the outbuildings. Has any consideration been given to placement of ground-mounted panels rather than on the roof facing Willow Street? That's a small number of panels to move to a ground mount, which would have a major difference in the visibility.
I personally don't think that there would be enough room to pass the code of the ground mount, being close to the main road and the property line of the parking lot behind it. It's unlikely that there would be clearance for the ground mount installation and through the permitting process.
Clearance?
You need to have a forbearance of about 50 feet in Yarmouth for ground mounts.
50 feet clearance?
From the property lines, yes. And the property line width is only 100 feet.
Is the white tube visible on the Willow Street side? Is that the exhaust for a septic?
I'm sorry, I think I misunderstood.
It is. Does that space help you with your space restriction that you just referred to? Could that be used?
I think I'm misunderstanding the question here.
That's not in the parking area. To my eye, it's got a septic tank there and an exhaust. Are you allowed to put panels as a ground array there?
I don't want to say yes definitively. That would have to be something that would have to be researched in order to have the ground mount be code compliant. And so I would not want to say definitively yes.
Would it be possible for you to research all alternatives for ground-mounted panels on the property?
Yes, in order to investigate it, absolutely, to look at that. What that does do, though, is that changes the financial component of it exponentially in order to have that done.
Well, that's...
I'm not saying that it's cost prohibitive, but what it does do is it does change.
Well, it would change because you'd have to put in some foundation work for the...
Foundation work.
For the ground-mounted panels, whereas you're just putting them on the roof of the house.
Yes, sir.
So you're getting a free ride, if you will, for putting them on the house, but you have to pay for the foundation to put them on the ground.
I agree.
That's economics.
I still think that that is going to infringe on the 50-foot barrier for code for ground mounts.
I don't know, I haven't measured it.
Yeah, in our measurements here, the property's only 100 feet wide, so to have that clearance, I don't see it
Well, I
fitting.
know that the rear and side lot setbacks in Yarmouth vary from 15 to 20 feet. So I don't know where the 50 feet comes from. I know generators may go up to within the property line. As to whether these would be considered generators or not, I don't know.
On that one, in order to see if there's an actual, our understanding could be creating more of a forbearance than would be necessary for that. So taking a deeper look into that in order to see if the compliance with the rule would, it feels as if that would be
Well, if you did that, then the amount of the forbearance would be unknown, would it not?
That's true.
I know there's been other applications on this home in the past. You guys are a different provider?
Yes.
So we had brought up, in one of the letters that was written from one of the residents in the town, was suggesting one of the outbuildings that also has a southwestern orientation. So as opposed to that portion of the route that's highly visible from Willow Street. And I know that I understand from my recollection was they might need some structural work to be stronger, but I'm just wondering. if you considered that.
We hadn't considered the outbuildings due to their current condition.
So, okay, Liz, go ahead.
Just to keep clearing questions up. I just went online to find out what the Liz Argo, Yarmouth resident, setback requirements. The minimum setback requirements are front yard depth of at least 50 feet, side yard depth of at least 50 feet, and rear yard depth of at least 50 feet. So that's specific to ground mounts.
Front yard.
And side yard and rear yard, so all yards, 50 feet.
We'll see.
What?
Did you hear that? She said that she looked up the regs, and it's 50-foot setback on front, side, and rear yards for solar panels.
We're only looking at 4 panels here.
Well, then we've approved a lot that aren't 50 foot from anywhere.
Yeah,
Ground mounted.
Oh, sorry.
I'm wondering if a variance might be possible, but wanted to say a word about Willow Street, because I think there might be some who are inclined to be somewhat dismissive of Willow Street in contradistinction to 6A. There's been historically, since I've been involved with this committee, a lot of discussion about Willow Street as sort of like the last stand of this committee. 6A as the last stand. Willow Street is one of the 2 major arteries to Yarmouthport from the Mid-Cape Highway. And there's Willow Street north of the railroad tracks and Willow Street south of the railroad tracks. And those are 2 distinctly different environments in terms of the structures. And this house happens to be on the corner of both 6A and Willow. So the prominent visibility from Willow in that location is very problematical to me. And it is my sense from hearing the discussion among my colleagues on this committee that there is a desire to find a reasonable compromise here, to allow the committee to accept the application with modifications, significant modifications, to permit the homeowners to enjoy the benefits of solar energy, which obviously they are very zealous about having, but still enable us to be true to our mission here, which is to preserve the character of the historic district. And it is hard for me to envision a property more prominent or central to that mission than 55 6A. So I would hope that there is a willingness on the part of the applicants and their representatives to work with us to find a solution for this that will satisfy the applicant and satisfy the committee. Are there any other questions or comments from the committee before I ask for questions or comments from the public?
Just a brief comment. I'm just going to say that if you allow this, you've opened the floodgates for Route 6A. So, there's ground solar, there's other kinds of solar. I think if you okay this, you will open the floodgates, having people say, look, there it is. And once you do that, you can't back off that, especially a house that's so prominent on 2 prominent roads. So that's my statement.
Other questions or comments from this committee? All right. Questions or comments from the public or abutters? Yes.
Hi, thanks for considering our application. My name is Al Starkey. I just have one consideration that is directed at you from the state of Massachusetts, and that is, have you considered significantly, quote, the impact of climate change in your decision? Now, you haven't decided yet, but that is a key element to what we're asking for. Number two, Willow Street. I mean, you really have to, take a quick look to see our house from Willow, where we're going to put those panels from Willow Street. It's almost impossible to see. So thanks for considering those things.
Other questions or comments from the public?
Yeah, I appreciate that we all care equally about the historic nature of this. And Willow Street, where we stand, isn't closer to or on the other side of the railroad track, where I've got a picture of solar on a building on Willow Street. So, but I hear you, Bob, you see it as significantly different. The thing is that we bought a home knowing we would be next to a parking lot, not knowing we'd be next to a wine store. The parking lot is lit 24/7. So for everyone who's got a historic concern, I would hate to do this to the Belzekians, but really it should not be permissible if we can't do other improvements to the area that we have to put up with 24/7 lights shining into our bedroom windows. So everybody has had to make accommodations. And I appreciate you wanting to find the right solution for us. One thing is we have planted 2 evergreen trees that will eventually grow very tall right at where the brick wall is at Willow. So they'll eventually get there. And we would be happy to plant several other trees, like arborvitaes that grow really fast, so that quick glimpse that you could get if you have to really want to see the panels, which, as Paul is saying, people will. Maybe it'll become an item, but we can block the view. So that's one accommodation that I can easily see. And the outbuildings really are structurally unsound, and we need a new roof as well. So there's all kinds of considerations here. But what my husband brought up is the climate bill that distinctly says that you cannot deny us or anyone for this unless you can significantly show that our house, of all the homes on Cape Cod, is not impacted by climate change. And I will await, if that should be your decision, I will await how you can articulate that in writing. So that's the dilemma that we face. But if there's a way that we can plant things and help out, we love living on historic 6A, and yet we willingly moved into a parking lot area. Thanks.
Thank you. Yes.
So at this time, what I would ask for is a continuance of this versus a.
Well, we have some more comments.
I'm sorry,
So that's,
Hi, Liz Argo. I also want to keep pointing out that the property 55 on Willow Street is right next to commercial business. And I think that's a really important consideration. And I listened very carefully to the letters that were sent in. I feel some of them are misguided because a lot of them were talking about being able to see these solar panels from 6A. Correct me if I'm wrong, but that is not what we're talking about here. We're talking about seeing the solar panels from Willow Street, and I agree that it's going to take a lot more than everybody who's breezing by Willow Street is looking forward because there's a stop sign coming up and usually traffic. They aren't going to be looking over to their left to the roof, which is also one roof amongst a whole, as we all know from the pictures, many different roof angles. This is just one more roof, and it will be black on black. And I think the tree covering that they have put in, if it really comes down to a denial, then what we've done in the past, from when I was running Cape and Vineyard Electric Cooperative, is put in arborvitae to conceal the view from the roadways. And if that's what we need to do, they are willing to do it. They've got a couple of pines on their way up and to the right height, and then that's a solution that maybe is the compromise that's needed here, is to go ahead and put in trees so you literally can't see 55 Willow Street or 55 6A from Willow. Thanks.
Thank you. Other questions or comments from the public?
Hi, my name is John Hunt. I own the Liberty Hill Inn bed and breakfast on the corner directly across the street, or a little bit of an angle, but across the street on the other corner of 6A and Willow Street, across from Just Picked. Bob, I don't want to argue with you or have a problem with what you said earlier before, but they have a very historic home, but I'm not sure the site of the first Liberty pole and the site of Ezekiel Hallett was mentioned in one of the letters. I'll speak for Ezekiel Hallett, and the history we bring to this part of the town is very important to me and should be just as important to you as it is to me. I think their goal is to come in line with the future of where we need to go for things like climate change. Coming down Willow Street, I understand what you said about Willow Street being pretty much like 6A. It's equally as historic, and it could be the last stand in terms of preserving that particular area of Yarmouthport. What has anybody done about the RV that's sitting on one of the properties up the street in Willow Street that everybody has to drive by constantly? It's horrible, you know. There's lots of different things along Willow Street that are less than pristinely historic, okay? I think what they're trying to do in compromising with you guys is to be very careful about putting solar panels and making it work, both historically and for the new environment. What you said about you open the floodgates, I don't agree with that. I used to be a police officer, and if I went around and arrested everybody that jaywalked, I'd be kicked off the police force, or anybody who spit on the sidewalk, I'd give a ticket to. The judges would be yelling at me for, what are you doing? You're wasting your time out there. Judgment is very important with these things, and you can use your discretion when it comes to things like this. And if somebody came along and said, I want to put my whole house down in Brewster, or the other end of Willows, the other end of like 6A, I want my whole roof to be solar panels. And look, you did it, you let the Starkeys have 4 panels. Why can't I have the whole thing? You still have the right and the responsibility to say no. That's your job. It's a red herring to say, oh, you'll open the floodgates. I appreciate what you're saying, and that's the fear, and I understand that the committee doesn't need to have 100 people coming up and say, well, you did it for them, why can't you do it for me? That happens to you guys all the time, And unfortunately, you do a really wonderful job at this stuff, and that's the uncomfortable part of your job, that once in a while you have to go and say, this is our discretion, and this is a no, and this could be a yes, especially if they're willing to compromise and do the best they can to hire those. One last thing. I come out my driveway and head up the street toward the railroad tracks. I can barely look at their house as I'm driving up the street, and the same thing going down to the stop sign. You better be watching out for how many cars are either pulling to the Liberty Hill Inn or pulling down to the stop sign and turning right. I don't see tons of people looking at that and saying, oh, look at that, solar panels, I can't believe this. We get a lot of foreign visitors at the Liberty Hill Inn, and a lot of the people that come from we have some people from England and Denmark this week. They think it's beautiful that we're doing things like this because they're doing a lot of this in Europe because of climate change. So I think it's a consideration that we all need to make for these things. Because I tend to look back and say, that letter was interesting, that they're bringing up the Civil War and, you know, who lived in that house years and years and years ago. Why would we have railroad tracks in this neighborhood, streets, telephone poles, you name it? At some point, we've accepted the beautiful historic nature of Yarmouthport to come along with the needs of society. We have cars now. We need streets. We have railroad tracks from the 1850s. I don't see where solar panels should be that scary to everybody, so long as people like you make us do a good job at having them in the houses that they're going to be put in, so that people don't go down the street and go, oh my God, what's that? So that's, I don't mean to insult you. I understand your fear is, as a committee.
No fear. No,
okay.
fear is not involved here.
Well, you know, I may have to come in front of this committee another time too, so it's hard to disagree with you guys, but, you know, that's just my, as a concerned neighbor. The other people that wrote those letters, they're not here tonight. I am. You know, I feel it's important enough that the Starkeys get a chance to do this.
Thank you. Any other comments from the public?
Why not? And I'll try to do this without losing my voice. Lisa True Grady, 415 Route 6A in Yarmouthport. I believe that preservation and climate change can work hand in hand. But I'm also tired of solar advocates portraying historic districts as the major obstacle in advancing their initiatives. Some of this I'm going to cut out, but I often wonder how many of the applicants that come in front of this committee have actually investigated other ways to retrofit their antique homes for energy efficiency. Historic New England did a valuable Zoom presentation on this subject. Do you know where solar panels fell? To the bottom of the list. Or how many consider the long-term consequences of maintenance, of dealing with a growing list of solar companies who have left the business, of putting their homes on the market with aging panels, and finding buyers do not want to be encumbered by the seller's lease terms or maintenance contracts. Your neighbors may be fine about where you want to install panels, but the next person who considers living there may not be, and they'll decide to purchase elsewhere. I see the Starkeys have just had their 10th anniversary of buying their home. We purchased ours 9 years ago, an antique property, a sea captain's home, but we understood the assignment, being that the Old Kings Highway Act was written and adopted by election for the protection and preservation of the history and character of our historic district. Along with many others who live here, we cherish these protections and don't want to see them diluted. Having been in real estate for 45 years, I liken the act to condo documents being reviewed prior to signing a purchase and sales agreement. If the bylaws don't suit your philosophy or plans, you move on and you purchase somewhere else. You don't kick down the door trying to make the association bend to your rules. For those of us who want to do our part in bearing responsibility to climate change, I have witnessed creative use of panels on non-visible areas of homes, the use of ground panel installations, as well as homeowners seeking solutions by participating in area solar collectives because they wouldn't dream of ruining the aesthetic of their antique home or neighborhood. The solar industry seems to be treating this legislation as if it provides them carte blanche. It does not. There is nothing in the legislation signed by Governor Healy that demands abdication of the responsibilities of members in any historic districts throughout Massachusetts. Nothing. These applications, especially where antique homes are concerned, are still subject to reasonable restrictions. And prior to Healy's signature, Historic districts along the Old Kings Highway were already granting exceptions and giving substantial weight to solar applications by their example of a 92 to 94% approval rate. For the last several hearings on this property, I have witnessed a committee trying to find alternatives for the 4 solar panels facing Willow Street. 4 panels. But each time the applicant has come back with the same plan. Excuse me, I'm speaking. Not true. I'm speaking. Good stewards who value the historic district work to overcome objections to visible solar panels, not, as Liz Argo has advocated at several public meetings, by using their application as a test case. I will end with a comment made by a committee member, Old Kings Highway committee member, during the last hearing on this application in November. Until the government tells us that we have to approve solar panels everywhere, we have to be selective. If the committee approves panels on this house, we have lost all credibility. I would ask that you vote to deny this once again. Thank you.
Thank you. Any other questions or comments from the committee?
I'm just going to say one last thing relative to your statement of the floodgates being opened. We had several applications for solar panels tonight, and Liz Argo came up immediately and said, my house, my neighbor's house, and a house down the street has solar panels. So that is the game. So the minute a solar panel is granted, then it has to be granted here and here and here. I mean, it's a discretionary thing. I get that. It's a discretionary thing. Okay, I'm done.
All right. I thought I heard a willingness on the part of the representatives from the solar company to think about this again. And certainly, I believe that there is a willingness on this committee to listen to a different plan. We'd like to find a solution here. Denying applications does not give me or anyone else on this committee pleasure. We want to work with the applicants and not be in an adversarial position, but working with the applicants frequently requires a level of compromise. So my suggestion is that we work to find a compromise solution.
We'd like to take it to a ruling. Based on what we've done so far, some of the alternative options that have been mentioned and suggested have already been explored. The ground mount opportunity is just not feasible based on the land area that's available there and the setbacks set by code. The other 2 structures would nearly have to be completely rebuilt to be suggested. So it's the wishes of us and the homeowners to take this to a decision by the committee.
So we are faced with the decision of voting up or down on this application.
I think that's all right.
You won't consider
we're open
a continuance.
we're open to other considerations, but based on the ones that have been mentioned here today, it doesn't seem like any of the other considerations would be viable options.
Can I ask one more question? We have recently seen applications putting panels on the north-facing roofs. Obviously, it doesn't get as much sun as a south-facing roof. The L at 55-6A, you've put 6 panels, I believe, on the southwest-facing side. How many panels could you put on the northeast side, and would that offset? And how much of the 4 panels that face Willow Street would that offset?
That's a great question. And the reason why is because these panels all panels have two configurations, landscape and portrait. So I don't have the measurements would have to be taken in order for that to be able to answer that.
Would be significantly less efficient. If my memory serves me correct, in solar terminology, that 4-panel location that is clearly the biggest issue has a radiance or sun hours factor of around 1,100 sun hours. Means that it produces at a 1.1 to 1 ratio of solar system to production. That northeast face would be significant drop, closer to around 750. It would not, filling up the backside of that roof would not replace what those 4 panels are doing.
But it would be someplace between eliminating the 4 and having 100% production.
Likely would not reach the 100% by adding this, to replacing the 6 panels there.
So instead of getting 100% of their electric bill paid, they might get 80%. Take a round number, 75.
Can I say one more thing?
Sure.
You know what, I know this is tough. This is our 10th anniversary, like Ms. Grady said. Today, 10 years ago, we moved here. And on
You
day
do that to this lady, Al. Surely it should have been in 2 weeks' time.
I missed that, sorry. Over the head. But anyways, day 2, when we moved here, I started volunteering on climate change and on energy efficiency. So the reason we only need 10 panels is because we have a very low energy usage. Every single year, we have done more and more and more that we can. We've done Cape Light Compact, energy of home energy audits. We do everything we can, including a little colder than we want to in the winter, a little hotter than we want to in the summer. But we're dedicated homeowners to making this a livable planet. I'm co-chair of the Faith Communities Environmental Network that's gone from 2 churches to now 47. I drive my husband crazy with how much I'm working on protecting this special, special place and taking good care of our home. But we can't afford, because we retired enough so that we can volunteer enough, we're not getting second jobs and things. So that money does matter. And truly the bottom line is a denial means you have to write an explanation for how you have taken climate change into substantial account. And I don't think that you can. And so I appreciate wanting to work with you. The trees we can do, but today we just need a decision, because to keep on coming back and then to invite more letters to come and tell us we're irresponsible homeowners. We're very responsible. We care very much about all the same things that all of you do. We're proud to be neighbors of at least 3 of you that we see all the time. But yeah, we really can't, afford to redo the outer buildings.
So can one thing occurred to me, because first of all, just to point out, your application does not state you're going to change the roof. So it's not in here anywhere. So that was news, but I'm sure putting on a new roof in your entire house is not cheap, right?
I don't know.
It comes with the panels.
Comes with the panels.
It does.
Well, my thought was, if you weren't replacing your entire roof in your whole house, and you could but just hear me out, just making a suggestion. If you were to leave your roof as it is, and I don't know how old it is, so maybe you want to replace it anyway, but if you were to leave it as it is, the 6 panels facing southwest are not visible from Willow Street. Now, if you spent some of the money that you didn't re-roof on fixing one of those outbuildings, I'm going to guess it'd be less money than a whole new roof. Is that an option? Just throwing it out there. I understand it's a financial consideration. I'm just wondering if that would be even cheaper than putting a whole new roof on your entire house. Just wanted to throw that out there as a thought.
Perfect, beautiful. We're doing a lease option, and so the 30-year-old roof, which really needs to be replaced, lucky us, until December 31st, when the federal law is changing and these incentives won't be available. But Evergreen Solar will be getting the benefits, the tax benefits. We will just be paying an energy bill.
So you get the roof for free?
Yes.
It's not just a tax deduction, you get the whole thing, they pay
Right.
for to put the whole roof on?
This is a big economic decision for us as well.
There's the rub. We're talking about economics.
There
We're
you
not
go.
talking about
We can't
climate
afford
change,
it.
and we're not talking about architectural review. Purview of this committee is architectural review. The legislation speaks to climate change, but it does not mandate approval of solar applications. Absolutely does not.
If you don't hear us talking about climate change and the importance of our historic preservation, which is why we're not putting it on.
About the economics of it, then I do.
There's three, yeah, you can do three things at once.
There is.
There always is. But anyway, if you, I don't know how you'll write it up if you are going to deny us, but you can't.
We've given significant weight to all of your applications.
Tell me how. Tell
No
me,
one on this panel
tell me
has taken
how.
Issue with the panels that are not visible from Willow Street. We're talking about 4 panels, okay? I maintain that those 4 panels in and of themselves will not significantly contribute to mitigation of climate change. They're an economic benefit for you.
And
That's it.
what is your point? I'm sorry.
My point is that they're not substantially, they don't give substantial weight to approval of this application.
So are you suggesting they just use the 6 not visible and eliminate the 4 that are? Is that what you're suggesting?
That
Well,
could be done.
I'm not first of all, Susan, it's your passion for this is palpable. We get that. And I think I speak for the rest of us that we are not insensitive to climate change, but we have a mission here. And it is our duty to uphold that mission. We're trying to find a solution. The nature of compromise is you're not going to get everything you want, and we're going to bend too. That's what compromise is all about. And it seems to me that we should put some more effort into exploring avenues for compromise. I want to say something about arborvitaes. I have some experience with arborvitaes and Leland cypresses. They grow fast and they're weak, and they fall, they topple in high winds. So screening out with vegetation is a nice idea, but if you want fast results from vegetation, you have to deal with the nature of the climate on Cape Cod and high winds, and I've had the experience of having fast-growing, shallow-rooted trees topple. So for that and for other reasons, trees and other screening vegetation has a way of disappearing. So to my mind, that is a solution in and of itself, although it may be economically attractive to you, isn't, from a practical standpoint, a sustainable answer to the issue of making those panels not visible or minimally visible. Yes.
In regards to the current design and the 6-panel layout on the south side, there is enough physical space to add a 7th panel, but we're crossing into a fire code setback. I'm not sure if it's the power of this committee to grant a forbearance on that single roof plane, but doing something like that may allow us to add a few panels to the back side of the 6-panel layout, which may meet everybody's goals here.
Certainly worth looking into.
So rather than calling for an up or down vote, why don't we go back to the drawing board? What do we have to lose? A little bit of time. I know that you've been here before, but this is a very difficult issue, as you can tell. So, and we want to get it right, and there may be a way of getting it right by virtue of compromise. So why don't we try that?
And I'd also just like to state for the record that the fact that we're working so hard to get this to work for you guys shows that we are taking into account climate change, and we want it to work for you. We're not saying, absolutely not, no way, we're not approving any solar panels. We want to try to figure out a way that it can work for everybody.
And you know, as was pointed out by Lisa Grady, historically, we have approved overwhelmingly solar panel applications that have come before us in the mid to high 90% range. Overwhelmingly, we've shown our support for solar energy. So this is a different case, and it's a difficult case. So.
Okay.
So, gentlemen, the ball is in, and Mr. and Mrs. Starkey, the ball is in your court. Do you want to try again, or?
We'd like to postpone the vote and come back to the drawing board for you.
You want us to vote?
No, he's
No.
going to
Postpone the vote.
postpone.
Okay.
Postpone the
Table.
vote. You want
Okay.
the argument.
All right. So,
Move
yes,
it-
sir.
I would like to create a caveat to our coming back to this, is we have a full understanding of how the community feels about this, but not to keep compiling more on top of it and leave it where it stands, but the understanding that there are certain no's in the community. I'd kind of like to pick up. where
I
we
think
were.
our focus is on visibility.
Okay.
That's our focus.
But we-
Just in a nutshell.
Okay, but as far as like 10 more letters coming in expressing, it just adds more energy and weight to the
I
decision.
can't control that, sir. The public has the right to speak, and people I've given everyone the right to speak here, and when letters are submitted to Old Kings Highway, we are compelled to read them into the record.
And I'm in full understanding of that.
Okay.
I'm just saying the addition of more, and I'd kind of create a neutral, but you're going to be using those again as more energy for that.
I did not solicit the record, the letters. Nobody connected with Old Kings Highway solicited the records. The records came from the good citizens who feel strongly about the issue. I have no way of vetting those letters or controlling who writes or what they say. Similarly to public comments that were made here tonight, I did not stifle anyone who wished to speak. And if letters came in support of the Starkeys, I would read those into the record as well.
Yeah, I understand. I was just looking for some sort of like, we are more or less saying, like, we understand where we're coming from, but if we have 100 more letters, it just adds a different weight.
Yeah,
to what we're doing. And we can't do it, and I understand you can't stop that from happening. I'm not
Right.
about that.
I think what we're looking for is for you folks to get creative and try and come back with something which is less, use of a better, I apologize for the term, but less offensive. Okay. Whereas less visible would be a better word.
Sure, Al. We're
As you know, this is the fourth time we've been back here. And well, for reasons beyond we really care, we're trying to respond, and yet I hear, we were looking for you to be more creative. Well, what does that mean? So we keep coming back and back and back. Is there criteria that we need? Is there a go, no-go gauge or criteria that tell us that, no, they won't accept that, but yeah, they'll be open to that? Is there anything that you can give us beyond be creative?
What we've heard over and over again is that
Excuse me, sir, I can't hear you.
I think what we've heard over and over again is that the 4 panels that are visible on Willow Street need to be less visible or invisible.
Okay. Is that the answer? Thank you, if it is.
I think if you review, by the way, this is all being recorded. So you can watch, and I would encourage you to do that. I would encourage everyone who has a vested interest in this application to watch the video and listen to what was actually said by the public, by members of the committee. There was a lot of good meat, useful information offered at this hearing. And I think if you have a chance to go home, relax, watch the video, listen to what was said, you'll get your answers to what would be, or some of the thoughts that we had as to what we could accept. I don't think we've been cryptic or mysterious about this.
Just, Elle, can I say one thing? Because I know this every minute of it inside and out. And the criteria last time was you can't have 3 of those 4 panels going vertical and 1 going horizontal. So, and I read the original paperwork too. It's like you cannot have a difference in size. So we left with, and I had to work with 2 different solar providers before we came up with Evergreen Solar to find somebody who had the right strength of power in their panels to be able, and size, to be able to put 4 vertical. So we came, it's not the same proposal as before. And we had other ones who wanted to put it on the northeast side, like John, you're creatively suggesting, but it was such a reduced percentage that it would be a little bit silly to put all that energy in and not get it back.
Well,
so we really did pay attention and have tried to creatively come back with, okay, so the main criteria was they all have to be in the same direction.
That's predicated on visibility. I keep coming back to the visibility aspect. That's the main consideration, I would say.
Can I just tease out from the gentleman in the light shirt there? You were suggesting that 25% of this, if I understood you correctly, can in fact be achieved by putting a 7th panel.
I didn't have an exact percentage, but if we can get a forbearance on the code, we can at least add another panel to that front side, which...
So that's one of the 4 that might be gone, he said?
Yeah.
In terms of visibility?
Yes.
So then maybe 6 on the rear would,
The more we put on the north side, the less effective and productive the system reacts as a whole, which, again, it changes the entire financial structure of the deal when things are happening that way.
well, I appreciate your willingness to look at alternatives.
Yeah, again, and I think the biggest thing and where I think maybe a lot of the frustration was is that the last time the Starkeys had come to this, their takeaway was that it wasn't the fact that there were panels that were visible. It was that there were panels that had multiple orientations and that it was a little bit of a hodgepodge layout. So when we came up with this proposal, it was, hey, this will at least be clean, symmetrical, and balanced from that perspective.
I think that was a misunderstanding. I think the objection was visibility.
So it seems to me that the last proposal was for 7 panels on one roof.
Yeah.
On one roof?
On one roof and then 3.
And there were 3 on another roof? Okay. Because for some reason, I seem to remember that 7 panels was the total amount that was going to give you the efficiency with just 7. No? It was always more than that?
11.
Okay, then I was confused, sorry.
Now it's 10, but it was 11.
And one comment about the economics of this. Our bulletin does charge us with considering financial hardship, but hardship is a high bar. I don't think you can correct me, Al and Susan, but I don't think we're talking about actual hardship here. So you may have to feel a little economic pain to achieve something we can live with. I'd love to see those panels on those outbuildings, and I know that's money. I get it, but it's a matter of priorities. You want the solar that bad, it has to be give and take here. And I'm not saying that's the only solution, but it would certainly be something that I personally would breathe a big sigh of relief were it to happen.
Just one more thing while I'm thinking about it. Just a quick thing, but we didn't mention this, and it hasn't come up yet, but in terms of visibility, aesthetics, the panels, first of all, we put a new roof on the house, all right? And the panels, it would be black on black, all right? Just so you know that that's part of what we're talking about here.
Definitely helps with the visibility issue.
So you're moving a little bit, we're moving a little bit, maybe we can get together. At the risk of sounding like a Pollyanna, which sometimes I'm guilty of. So, I think we have an understanding, so I will entertain a motion at this point.
I move to table application 25-A099.
A second.
It's been moved and seconded. All in favor of tabling this application until when would you like to come back, gentlemen?
Is that a free date, or I would imagine it's the next scheduled?
Well, can you be ready in 2 weeks?
Yeah.
When you're ready with the,
You can just let me know when you're ready.
Yeah, we'll be ready in 2 weeks.
The 28th is the next meeting. If you've got a new plan, just email that to me, and I'll get it out to the group.
Okay.
Whenever you guys are ready.
Thank you.
okay, it's been moved and seconded. All in favor of tabling the application signify by saying aye.
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 Can we add happy anniversary?
Yes, I know this was a joyous anniversary for you, and we're so happy we were able to celebrate with you.
How many years?
10.
Oh, since you moved in, not your wedding anniversary.
Oh, that's this year too.
That's this year, too.
25.
Well done.
Okay, all right.
Thank you folks. Have a good evening.
All right, good evening.
Thank you.
Thank you.
Thank you.
Okay, we need to approve the minutes of the June 23rd hearing.
I move to approve the minutes of the June 23rd
Seconded.
meeting.
Seconded.
Been moved and seconded. All in favor of approval signify by saying aye.
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 All right, the next meeting is July 28th, and I will entertain a motion to adjourn.
So moved.
Move to adjourn.
Is there a second?
Second.
All in favor signify by saying aye.
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 Aye, we are adjourned.